of 1999.
I appeal for the plaintiff,
My lord, it fixed to keep the cross-examination tomorrow. I have some difficulty. I was praying, my lord, any other day convenient to this court, my lord.
Tomorrow.
Yes,
Tomorrow, my
it,
lord.
it is that Mr. The matter which was two witnesses are being cross-examined on recall.
One witness has been examined.
Examined.
PW2.
The second
Come
PW2.
tomorrow.
Tomorrow I have some
I will
difficulty.
adjourn it.
Oh, very well, my lord.
I will adjourn it.
I'm grateful, my lord.
Just remind the
My lord, I'm grateful.
Yeah, but may I have my lord's leave to mention a matter, my lord? But this is a suit of 1999, my lord. My lord had passed an order dismissing the suit. I was for the defendant, my lord. But in the suit, there was a bank guarantee which we were required to place.
You need return of the bank.
Yes, Lord. I mean, we had written to the registrar original site, and the registrar has communicated to us saying that there has to be a specific order by the court with regards to the return. But may I hand over the order copies for a moment?
Kalke rakho, kalke. Keep it tomorrow.
Deeply obliged.
This matter is already appearing before court number 41, my lord. I do not know. Determination change.
Check kore do.
Now the 13 suit is
2013 suit.
Yeah.
So it will appear in the list.
Lord, 2010 suit, Lord. This was appearing in the list of Lord court number 41. Thereafter, Lord, for renumbering from the regular suit to a commercial suit, Lord, it was posted out of Lord list. Now, Lord, it has come up in the list as item number 132, appearing at page 133 of the list of this original side, Lord. Let this matter
Check
be
it.
Lord,
For inclusion.
for inclusion.
They will check it. Manoj check kore do.
Lord, may I be permitted to mention a matter? Lord, this is with regard to the Calcutta International Club, Lord. That matter where we were trying to do a restoration at the same time an amendment. Lord had indicated both the GAs in the order passed on 1st March 2024, but the order only the restoration has been allowed. The nothing has been said about the amendment in the same GA. Lord, may I kindly hand over the order? Millard had indicated at the top GA7 and GA8 both, but only with regard to the direction GA7 the directions have been passed. Well, GA7 is the restoration which your lordship had allowed.
It will appear in the list.
I'm so grateful.
My lord, may I be permitted to mention one matter for correction, my lord? The order was passed on 26th February, my lord.
We'll come tomorrow.
Commercial division, 4 suit, item number 1, Jalan Aerospace Private Limited. In this matter, I appear for the defendant.
I'm for the plaintiff.
Use microphone.
In the matter, I appear for the defendant. There was a direction for inspection of the documents, my lord. We have completed our inspection, my lord. The defendant has given that inspection, but the plaintiff, there were two agreements which was not placed on that day. My lord, I think in the meantime they have got it.
We have given inspection of one document, my lord. One document. We will be giving inspection in
I am
court.
fixing for framing of issues.
Yes, my lord.
Complete.
My lord,
No,
issues have been framed.
Issues
Issues
are
have
framed.
been framed, but I believe, my lord, the judge's brief
Because
is also
last
filed.
day adjournment was
Yes,
parental.
my lord. My lord, thereafter I have taken steps, obtained the documents, given the inspection
briefs are
in
filed?
respect of most, my lord.
Judge's brief.
Judge's brief has been filed, my lord.
Both the parties.
Both parties have filed. My lord, now it will come up for evidence. My lord will kindly grant us 7 days to complete the inspection and we'll come back. The document is also in our possession. We'll just provide them the inspection on any day and we'll come back.
Adjourn to 13th March.
Much obliged.
ইস্যু তো ফ্রেম হয়ে গেছে বললো দেখো তো issue। Item number 3, undefended suit.
Lordship, I am appearing for the plaintiff.
Lordship was pleased to direct the department to trace for Lordship the application which was not traceable. Lordship the department was supposed to file a report and the GA, Lordship.
Who is the plaintiff?
Lordship, I am appearing for the plaintiff.
You are for?
I'm for the defendant.
But this is undefended.
Your Lordship.
Lordship, it's undefended because the written statement was not filed in time, Your Lordship. Here the application is for the substitution. We are saying that the Lordship, the application, the suit has abated because of the application which was filed at least 4 to 5 years back. After that, Your Lordship.
What about GA number 7 of 2014? The report is silent on this.
Lordship, you have asked for, Lordship, now it has GO7, Lordship. Perhaps it was application, old number.
1031.
Old
Yes,
number was
but that this report
1031,
is not in
perhaps.
respect of this GA.
Lordship.
Something else.
Lordship, as per your Lordship's last order, the department had to place records on GA7 as well as GA2606, your Lordship.
Nothing. This is silent about GA7.
Lordship, the GA7 old number is, Lordship, may I?
Yes, the report is silent. Report of the learned registrar original site dated 5th February 2024
1031. 103.
7, yeah.
is silent on GA7 of 2014. এটা আছে কি এখানে? হ্যাঁ? ও তাহলে ছেড়ে দাও। Yes, GA7. Recalling order dated 18th March 2014.
Lordship.
This is GA7. Who filed this?
Lordship, we have filed.
Lordship, here the order was,
Dismissed for default of the other GA.
Lordship. And that was to be restored upon payment of cost.
Lordship, the cost has already been paid, your Lordship.
They could not show me, Lordship, but the cost was paid to us or not, because that was the term, your Lordship. As per the last order, Lordship has given
Where is
us.
this order?
Lordship, if I can place this letter, your Lordship. By this letter, a check of rupees 3400 was handed
Which
over.
was the order of restoration when it was passed?
Repeat. That was on 10th September, your Lordship.
Payment of cost. Have you paid cost?
Lordship, if my hand.
File a supplementary affidavit.
No, Lordship, this letter was given to us. Lordship will see there is no receiving from our end. It is their letter.
You filed supplementary affidavit.
Lordship.
There is no receiving from us, your Lordship. To that extent, your Lordship, it's their letter, no receiving, nothing, your Lordship.
GA 2606 was dismissed for default.
Lordship.
Now GA 2860, that was restored. You go through the order. Which application is restored?
2860 was restored, Your Lordship. If Your Lordship sees the 10 September 2014 order, 10 September 2014 order. Your
Yes,
Lordship.
2860 was restored.
On the top, Your Lordship will see.
Yes, it was restored.
2860. So it was passed in 2860. It was restored upon payment of cost. And now after this, the another application which is there, Your Lordship. Now that is there for the restoration.
GA7 of 2014.
Lordship.
This is for restoration of
This
basically recalling of the order dated 18th March 2014.
This is the restoration, Your Lordship, for the substitution application, which was.
I do not know what this application is, but GA 2606 was dismissed.
So they have not given us, Your Lordship, GA7 has not come, Your Lordship.
GA7 is now today before me.
Lordship.
This is another order.
Lordship,
I also do not have the copy, Your Lordship.
Lordship, GA7 is for
Copy
restoration.
hai?
Lordship, if the defendant does not have a copy, I can serve it. Lordship,
No,
I don't
you
have
have,
it. Right.
you
Yeah,
have.
yeah, I have.
Give me the copy. No,
I just have one copy.
no problem. I will return you.
What this application is about?
Lordship, this is for restoration of your lordship.
GA7 is for restoration.
Yes, your lordship.
Now,
But-
what about this GA 2606, which was dismissed?
Lordship, GA7 is for restoration of order.
Affidavit of service it is.
1 minute. Lordship, GA7 is an application for restoration and recalling of the order of dismissal dated 18 March 2014 of GA number 2606 of 2012.
What about 2606?
That is, your lordship, that was dismissed for default
What this
by
application was about?
That is for the
Lordship for
amendment.
substitution.
Substitution.
Substitution of the name of the plaintiff, your lordship.
So we are not concerned with this order of 10 September 2014 because it was restoration of 2860.
Lordship.
This is altogether a different application.
Lordship.
Lordship. That was
So
also an application for restoration.
Yes, we are now concerned with this application.
Seven was dismissed. For that application was filed for
7
restoration.
was not dismissed.
Lordship, 2606 was
We are
dismissed.
confusing the numbers. 2606 was dismissed for default.
Which has been renumbered as 7.
Absolutely
No.
not.
Lordship,
7 is for, please, 7 is for restoration of this application.
Oh, Lordship, sorry.
Try to understand these things. 2606 was dismissed by order dated 18th March 2014.
Lordship.
Now this application, this 7 of 2014 is for restoration of that application, 2606. Because 18th March order is concerned with GA 2606. You do one thing, you file a fresh substitution application.
Lordship.
Have you any copy of this order, copy of this application?
Lordship, 1031. Earlier 1031, now GA7, your lordship.
I am not, can't understand what I'm saying.
Lordship.
I am speaking of GA 2606, that application which was dismissed, which you want to restore.
That is a restoration application.
This is restoration application. What is that application which is dismissed?
Dismissed,
Lordship,
that is
that was
substitution application.
Show me that application. It's okay, it's here.
तो मास्टर समझते थे यार, मास्टर समझते थे.
Now this GS7 is to revive this GS 2606 of 2012. So 2606 is for basically substitution. It was partnership form. Now it is proprietorship form. That application. So unless this was done, you cannot do anything. GS7 of 2004, 2014 is filed for recalling the order dated 18th March 2014. Passed in GA 2606 of 2014. Full stop. In terms of the said order dated
Lordship, it
18th
is
March 2014,
2606 of 2012, Your Lordship.
2606 of 2012. In terms of order dated 18th March 2014, GA 2606 of 2012 was dismissed for default. This application was filed on 3rd April 2014. এটা কবে ফাইল হয়েছে?
Lordship, 27th March 2014, Your Lordship.
No, filed on 3rd April 14.
Lordship, it was listed on to be listed on 3rd April 2014.
March it was shown on, but it was possibly
Lordship, 27th March.
3rd April. 3rd April. 27 March 2014. Ground furnished for restoration are proper.
Lordship, may I interrupt? They are saying that they have paid the cost. Lordship, just now they have paid
Not
the
in
cost.
connection with this one.
Yes, Your Lordship. That is what I'm saying.
How can you
Lordship will
say?
see the 10th September order.
10 September order is in respect of GA 2860.
Lordship.
This is not 2860.
So this until unless this is restored, this cannot be restored, Your Lordship. Upon payment of cost, it was restored.
Which
So,
was?
2860.
2860 is not before me.
No, I'm not on that, Your Lordship. This was dismissed for recalling of this order, Your Lordship, which is passed here. So this was restored upon payment of cost.
Lordship, but that is a different.
I can't understand what you are saying.
May I place, Your Lordship? GA number 2860 was dismissed. This application 6, Lordship, that is GA number 1031 was dismissed. And for this, GA number 2860 was filed.
Lordship.
No, this order is not clear. I do not know which order is restored because this is not
here. It is there in 10 September
this is
order.
not in connection with these two GAs.
Lordship will see once the 10 September order. That is there in 13th
You explain
August
me.
2014.
You explain me. What is there?
Lordship, it's there.
For
Order
what?
dated 13th September.
For what?
Restored.
13th September.
2014.
I am not concerned with 13th September
That is
order.
what I am saying, Your Lordship. The dismiss of this application 1031 was dismissed as per the order 13 August 2014.
Where is 13th August?
Lordship. So
Where is that order?
that is 13 August, Lordship, the application, you will find it in this application, Lordship, this 2860 application, you will find that order. 2860 application, you will find it that order.
Why
It's
should I
there.
look into
It's
2860?
here, Your
No,
Lordship.
tell me,
It's-
why should I look into 2860?
I'm not looking into that, Your Lordship. Only I was beseeching, Your Lordship, that the 2860, when it was, this application was moved for the restoration of this 1031, order was
Lordship,
passed.
1031 is a new
Lordship,
GA, your lordship. How can it be restored, your lordship?
I'm not on restoration, Lordship. When this
1031, how 1031 or GA7 is connected with
that
2860?
is what, Your Lordship, I'm saying. May I start from the one, Your Lordship? It's there. This application 2606 was for substitution. It was dismissed. By an order dated? Lordship,
18th April, 18th March.
Lordship. It was dismissed. So for 18th March order restoration, this application 1031 was filed. This was also dismissed. As per the order 13th August
1031
2014.
was dismissed.
Lordship.
Where is the mention of 1031?
It will come here in that will be reflecting in here, Lordship. That is in 2860, Lordship will see that application.
Where is 2860? Oh, 1031 of 14 was dismissed for default.
Lordship. And for that restoration, this application 2860 was filed, wherein this order was passed upon payment of cost 13 August 2014. Order was recalled.
Okay.
Lordship, I have been able to make myself
Now,
clear.
have you paid?
Lordship, we have paid.
That letter does not reflect our receiving, a Lordship. That has their letter, everything, but
This
our
plaintiff
signature
is not
no
very
receipt.
careful about the suit.
Lordship,
Plaintiff is not very careful about the suit. Things are getting dismissed, restored, no payment of cost.
Lordship, the cost has been paid, your lordship.
Come with the supplementary affidavit tomorrow.
Lordship.
Not today. But tomorrow I will pass order. I have wasted enough time here for this.
Deeply appreciated.
Come tomorrow with affidavit.
Regular list. Item number 1.
Well, I am for the
Well, I'm for the
applicant.
plaintiff.
Well, this application, IAGA number 14 of 2022, is for recalling of 2 orders at page 16.
Who is your other side?
Well, I'm for the plaintiff, Lord.
Yes.
Lord, kindly fixes any date for hearing this
Any
matter.
kind-
This should be a commercial dispute. This suit should go to the commercial division.
Commercial division.
Sounds like commercial dispute.
Anywhere but only problem I am facing, I am telling your lordship, the urgency is my learned friend client is claiming to have a decree in its favor. Our contention is appellate court has made a full remand, open remand. So there is no decree. And my section 47 application is pending, is being heard in some other court. So kindly keep it, my lord, as early as possible, subject to your lordship's kind convenience. Any day next week.
What is the plaint? What is the dispute?
Dispute is money claim, basically.
So it should go to the commercial division.
May it appear in your lordship's list in commercial division.
The suit, the dispute involved in the suit is of commercial nature. Post of the learned senior counsel, Mr. Ghosh. submitted that the suit may be transferred to the commercial division. Let the suit be transferred to commercial division. Department is directed to do the needful. The plaintiff parties shall take steps accordingly.
No, only
I'm
one,
making a short date.
only Milord, for plaintiff, my learned friend is appearing. Let it be his submission because he has the
Right,
carriage
his
of the.
submission. Learned counsel for the Mr. Mitro, the learned counsel for the plaintiff.
ক্রাইটেরিয়া মিট করছে যেটা কমার্শিয়াল ডিসপিউট দেখতে হবে ফিগারটাও তো ম্যাচ করে যাবে obviously
I think this is a commercial dispute.
that I have to check whether there's an agreement.
Not
a-
necessarily agreement because this
Money-
is a dispute relating to commercial transaction between the parties.
Yes.
Milord, may we come in the next week and
দেখে
after
নিই,
my
আমি
learned
একবার
friend
দেখে নিই।
checks up because it is his suit, then Milord,
আচ্ছা ঠিক আছে ছেড়ে দাও।
সেটা এবার কমার্শিয়াল হবে এটা
On prayer of the learned counsel for the plaintiff, check it.
My lord, I will-
Apparently
I will-
sounds
I will-
like commercial dispute.
Yes, it sounds like that. I have not.
The suit is adjourned to suit along with the application.
Next Monday it can be, huh?
next Milord, Wednesday, Monday, Tuesday arguments are support মামলা করবে।
হ্যাঁ।
Next Wednesday,
টু বি মেনশনড আসবে না কিসে আনছেন
no, for hearing.
কনভার্ট হতে গেলে হ্যাঁ
Let first
Yes,
let it be
yes.
fixed for hearing.
yes no my lord we have to then in the event is a commercial then it will convert it first and then hearing will
Right
take
now I am not going into this.
yes so let it be as to be mentioned
To be mentioned.
yes
Appear in the list
so we can
on give a date.
but any day when we give it 2 days time I'll just read the papers and come back to your lordship. It can be on Friday also or Monday Tuesday whatever
8.
হ্যাঁ আমি তো just I'll read the cost papers and come back to your lordship
Yes.
whether it's commercial
Because
or
if it is to be transferred to the
yes
commercial division,
that's
it will be
only that
one line order.
yes I'll just check up
Great.
Item number 2.
For item number 2, I am appearing for the plaintiff, but the problem is I did not know the suit is dismissed for default.
This suit.
This suit.
So my application, your lordship, this is my application. I am for the defendant number 1. So dismissal of the suit, your lordship, will not actually come in the way.
Oh, but if
In your
suit is
lordship, this
dismissed, everything goes,
No,
madam.
your lordship, this is a consequential relief. I'll satisfy your lordship. Your lordship, kindly take my
It was
application.
deposited.
Yes. So it has to
Well,
be disbursed, your lordship.
Well,
And
let the suit be restored and then
I don't think your lordship, the plaintiff has any objection because that is by virtue of a order of the court. If your lordship
No,
kindly
this
take
is basically
once-
consequential order. If the suit is restored, then another issue will come up whether we have to adjudicate upon the suit. So this order may not be passed. This order may continue.
this money, your lordship, is admittedly.
Yes, when the plaintiff is not interested to proceed
no,
with
we are interested, my lord. We will file an
the
application.
restoration application, where is the
We
dismissal
will
order?
file, my lord. My dismissal I have given, my lord. It was dismissed last year on March.
But I don't think, your lordship, regarding the disbursement, the plaintiff has any issue.
I may have to file an application.
Till now, I have no application.
No, there is no restoration application, my lord. I'll be candid, my lord.
But this money, your lordship, has been deposited by.
Where is the order of dismissal?
Well, I have handed over.
He has handed over, your lordship.
Have you mentioned this?
No, your lordship, this particular, my application, your lordship, is a consequential relief. Now, your lordship,
But they also did not
Yes,
know.
in your consequential relief,
Lordship.
because suit is dismissed.
Lordship.
And you will be absolutely silent that the suit is dismissed, you are seeking for consequential relief. You will not mention the date of dismissal of the suit.
So we also had no knowledge regarding the dismissal of the suit.
Come with a fresh application.
So my application is nothing to do with the dismissal of the suit. Even if the suit is dismissed, I am entitled for the
Yes.
money.
If the suit is dismissed,
Yes, your lordship.
then why have you mentioned the suit is dismissed?
No, that is not mentioned in
Then
my application. That's
Why,
true.
why should I pass any order for restoration during pendency? That would be one consideration.
Lordship.
After dismissal, consequential relief, that would be separate consideration.
Lordship.
Where is the basis of that prayer?
We will file a supplementary affidavit annexing this particular order. if
Take it
required.
off, file a new application.
Lordship, is already, Lordship, this particular dismissal of the suit will not affect my application, your lordship, at all.
How can I know there is a dismissal of the suit? Have you pleaded this?
No, sir, I have not pleaded this because we had no knowledge regarding the
Then-
dismissal of the suit. I am the defendant number 1.
Then why are you harping the same thing? This is dismissal, suit was dismissed. Suit
I
was-
will file-
Consent, this suit
I
can be
will-
restored and he can
I
apply.
will file a supplementary affidavit. There won't be any problem, your lordship.
So on consent, the suit can be restored. But that was an
The
admit.
money is lying with the receiver, your lordship, as per the order of the honorable court.
You are harping that. I know you are interested only with the money. But tell me whether the suit was dismissed or not.
Suit has been dismissed.
That you are also reiterating without mentioning when it was dismissed.
Order has been, Your Lordship, handed over by the plaintiff. We had no knowledge regarding that.
Take knowledge.
I'll file a supplementary affidavit, Your Lordship.
Leave it. Prayed for filing supplementary affidavit. The same is to be filed within 7 days.
Lordship. And Your Lordship, as per Your Lordship's order, we have served the copy of the application to the learned receiver. Your Lordship, he is
The
present.
suit will appear in the list on. The matter will appear in the list on 5th April.
And Your Lordship, the learned receiver, Your Lordship, is here. Kindly, Your Lordship, record because there is a direction.
No direction, nothing I will record.
No, Your Lordship, there was a direction of the Honorable Court, Your Lordship, for the presence of the receiver on the last occasion,
Was that
20th
the
February
Honorable?
2024. The learned receiver shall present in this court on the next day.
The learned receiver is present in the court. Adjourned to যেটা বললাম supplementary affidavit 5th April.
5th April.
Your submission should be based on pleading.
Lordship.
It's not a submission in wilderness.
No, we had no knowledge and we will file a supplementary.
What then why you are reiterating this if you have no knowledge?
We will file a supplementary.
Item number 3 and 4.
I appear for the plaintiffs.
Lord, GA15 is my application, my lord, if your lordship remembers. But if your lordship takes your lordship's last order, Mr. Bachawat for the defendant number 1 was continuing his submissions.
Yes, আমি ভুল ভাবলাম অন্য কোনো মামলা শুরু করে আমি বলছিলাম তো।
Yes.
Yes. Mr.
Lordship gives me a moment, Millard. May I just, Millard? Millard, I'll not repeat anything, Millard. I'll start from Millard, where Millard, Mr. Bachawat has stopped.
Basically, your point is to return of this.
No, I don't want Millard. They want Millard. Millard, the plaintiff, the intervener.
He wants transfer of shares.
He wants, Millard, the orders in a suit where he is not a party. And there he has said he doesn't want to be a party. But he is asking an order in nature of mandatory injunction, Millard, which is provided under this specifically.
Yes.
Whether, Millard, that is permissible in law.
You are opposing this.
Naturally, Millard, I am the
submission?
defendant. Millard, my submission is, Millard, if he wants such type of order, Millard, he has to file any sort of proceedings, original list, where, Millard, these orders can be passed, may not be passed, we'll come and argue. But so far this suit is concerned, he is not a party. B, Millard, the prayers which is in the plaint is directly, Millard, contrary, Millard, to the reliefs claimed, Millard, by the, Millard, so-called intervener.
Which one?
Kindly have a look at, Millard, the prayers, Millard. The application is, Millard, very, Millard, short application. What prayer? In law, Millard, can it be granted? And that too, Millard, after 26 years.
Leave granted to intervene in the present
Leave
suit.
be granted to the applicant to serve copies of the present application upon the plaintiffs and the joint receiver. No difficulty.
But so far as C is concerned,
kindly have a look at, Millard. Prayer A is most important. It is not an application in the nature of Order 1 or Order 1 Rule 10(2) for addition of parties. It's an application, leave be granted for the applicant to intervene in the suit. Under what, Millard, provision, I don't know. Either you are a party, you ask yourself to be implemented as a party or not as a party. Or you file a deletion, Millard, under Order 1 Rule 10(2) for addition, deletion. So first prayer is a misconceived prayer. Now, Millard, kindly have a look at C. Something, Millard, an order in interlocutory court, Millard, can be in aid of a suit.
By a non-party.
By a party to the suit.
Non-party.
By a non-party. Even, Millard, a defendant, Millard, cannot get an order in aid of a suit, Millard, 7 except, Millard, otherwise provided in Order 39, Millard, Rule 1B, Millard. That status quo should be preserved. He cannot get an order of mandate, even a defendant, without a counterclaim. Now, Millard, look at his prayer, Millard. Whether Lordship, Millard, sitting in this jurisdiction, Millard, can grant him a prayer. An order be passed directing the joint administrator, Mrs. Lopluchi Company, to forthwith register the transfer of 460 shares, paid up capital of share, rupees 10 each to Messrs. Lokchuti Company Limited in favor of such and such. Now we'll have the next order. These are mandatory orders. An order be passed directing the joint prayer D, page 11, of Messrs. Lokchuti Company to return the original share certificate bearing certificate number such and such, distinctive number such and such, after recording transfer of the share on the face of the original share certificate being certificate number 1. This had to be filed, Millard, for rectification of share, Millard, because it's, Millard, the company in question, Lokchuti, is an unlisted public company, Millard. So, Millard, the provision is 111 capital A for rectification of share register. That has to be filed, Millard, in a forum that was available that day. It's company law board, Millard. He has not done so. Now, today the forum is, Millard, the NCLT, section 59. That's a statutory forum. Unfortunately for my learned friend, Millard, that forum, Millard, is the only forum today available. A suit will not lie because the proceedings will be hit, Millard, under section 430 of the Companies Act. So something which he cannot achieve directly by filing a suit in this court, he is, Millard, seeking to do it indirectly by filing an application in aid of this suit.
All right. Who is the other side?
Millard, I have many other points, Millard, to make, Millard. Lordship will hear.
I will finish it. I will pass order. It is pending for long.
My lord, I appear for the plaintiff, my lord.
Millard, I have to show, Millard, judgments on this, Millard, with your lordship. This is not permissible in law. Kindly, Millard, takes, Millard, the plaint case once. Kindly have a look at the plaint. Lordship has a copy of the amended plaint. Kindly have a look at the plaint case. The plaint was amended numerous times, Millard. Kindly have a look at the plaint case. In fact, the plaintiff says, Millard, the status quo should be maintained. Kindly have a look at, Millard, paragraph number 5. My learned friend wants a shortcut which is not permissible in law. Apart from the plaintiff numbers, paragraph 5 of the amended plaint. Apart from the plaintiff numbers 2 and 3 and the defendant numbers 1 and 2 between themselves, hold 49.27 shares each of the total share capital aggregating to 98.54. The balance 1.46 share of the shares of the company are registered in the name of the following person: Administrator General of West Bengal 1.34%, PG King 0.12%, Millard and Millard 1.46%. So, Millard, the plaintiff and the defendant both are holding, Millard, 49.27% shares in this company. So that is the status. Now 560 shares may look, Millard, superficially, Millard, that, Millard, it's nothing. These 560 shares, if, Millard, one of the parties either through themselves or through relatives, Millard, he gets control of 51%. And he runs the company by majority. That is the plaintiff's case, Millard, that these 42% shares should be, Millard, preserved. And, Millard, he is saying so. Now, Millard, kindly have, Millard, one more paragraph, Millard. I'll be very short, Millard. I have marked the plaints, Millard. It's a huge plaint after the amendment. Kindly have a look at. First, Millard, Lordship will take the, Millard, prayers in the suit. Or, Millard, Lordship will straight away come. 21. Capital B, page number 25, capital A of the amended plaint.
21.
Capital B at 25, capital A of the plaint. The plaintiff are also entitled to a decree for rectification of the register of members.
21B.
21 capital B of the amended plaint, Millard.
Yes. Resolved that authorized.
No, it's, Millard. I have 21A, 21B. It's a, Millard, new came up by way of amendment.
Yes. 21A is 13A, chapter 13A.
No, some, Millard, 21 capital B. This is the plaint look like this, Millard. This is the amended plaint. And last date, there was a direction that the amended plaint should be on the board. বলবেন তারপর চলে যাবেন, যতক্ষণ বলার বলুন।
হ্যাঁ, amended plainted কোন জায়গাটা বলছে? You check it.
I'll check it myself, Millard. What is the plaint, my lord? There was a direction, my lord, for production of, my lord, the amended plaint. এই তো আছে তো ও পেজ দেখছেন জজ সাহেব আমি 25 ক্যাপিটাল এ পেজ নাম্বার বলছি 25 no it's on order I was referring to Millard the page number lordship was looking para number lordship was at the page number so 25 capital A is the page number and 25B is the para number paragraph number the amended portion is in Millard white page Millard because it's a newer Millard page
25A, 21B, yes.
21.
Plaintiffs
The
are also
plaintiffs
entitled to.
are also entitled to a decree for rectification of share of the register of members by deleting the names of the defendant numbers 3 and 4 in respect of 7500 ordinary shares and the plaintiff is shown to be standing in the names of the defendants in the
So
register
according
of
to
the
you,
plaintiff.
this adjudication of
plaintiff-
this thing will be affected.
Absolutely, because we the prayer. Kindly have a next line. The plaintiff has also entered decree of rectification of register by deleting the names of defendant number 3 and defendant number 6 to 10 to whom in the register of members of the plaintiff in
I
respect
got
of
your
100
point.
shares. Now, Millard,
Whether
he is
this-
on the one hand, Millard asking that Millard this status should be maintained. On the other hand, Millard he comes, he sets up a person, Millard, who is Millard his relative. Millard, he wants to alter the status quo and get Millard 560 shares so that he can run the company. And Millard, kindly look the mala fide, Millard. Kindly look the mala fide. Kindly look at Millard, the prayer portion of the plaint. I'm very sorry. Kindly have a look at page 32, prayer M. Other prayers will come, Millard. Look at the mala fide. How vicious the plaint is. Prayer M, perpetual injunction restraining the defendants and each of them from altering the shareholding position of and in the company by issuing allotment of further shares in the name of the company. It's your prayer. You are asking, the plaintiff comes for an ask that, Millard, there should be no allotment, no further issue, Millard. The shareholding should be preserved. And Millard, after 26 years, he sets up his relative who is asking for alteration of Millard this shareholding by Millard asking for an order, Millard,
Whether
which
he
is
has
impermissible.
set up a relative or not, that's separate.
That's not denied. I have alleged he has not denied. I have alleged something.
Basically, the thing is that an outsider is coming to intervene into the suit.
Yes.
For passing such order.
Yes.
Which according to you is not tenable because this will affect the adjudication of the suit.
Absolutely. The status quo.
This is your point, Mr. Bachwat?
Yes. Yes.
This is your point.
But this is one of the points.
One of the points.
It's more a point of prejudice, Lord, in this sense. Lord, please see this situation, Lord. Company. There is a company which has become the subject matter of the litigation. The basis of the litigation filed by the other side is, look, it is 50-50. Equal on both sides. You are attempting to change that status quo. This was the basis of his suit. Those pleadings I have showed you last, I have not on the last day. Now, Lord, he gets an order which is in the nature of a status quo. Everything has been frozen. Now, thereafter, Lord, this story of 560 shares comes up after the suit. Now, even when he amends it, this 560 shares is not there. So, it's not the subject matter of the suit at all. Now, I file a 397 the moment this story about 560 shares comes up. There, I have specifically challenged that, look, these shares cannot be recorded. That is the subject matter of my 397. I've showed your lordship the prayers on the last day. So, in a properly constituted proceeding, Lord, under section 397, Lord, the CLB, it was then CLB, which is the only body which could have decided this dispute. Lord, was in session. Now, he says, look, in my suit and between your 397, there are common issues. So, he applies for stay of that proceeding at a very belated stage, at a point of time when, Lord, the CLB in exercise of powers under the old section 402 of the Companies Act was going through the exercise of compelling one party to sell and one party to buy. That power it has under 402. It is at that stage that they ask for a stay. And the order passed is, look, that proceeding will be decided after the High Court suit. Now, the intention, therefore, is these 560 shares, nothing happens to them. which is also the reason your lordship will find he did not apply before this suit. Now, we had applied in this suit saying, please, as far as these 560 shares are concerned, they should not be, no order can be, please restrain him from doing it. To which his opposition is, look, it's not within the subject matter of the suit. These 560 shares is not the subject matter of the suit and no order can be passed. That was his case there. That also I showed your lordship on the last day. So, my lord, what is the position which emerges from here? Number one, my lord, there's a suit. Your lordship has seen from the cause title that the applicant is not a party to the suit. Number two, the shares are not the subject matter of the suit. Number three, the prayer he is asking for will be tantamount to a decree. Because he is saying, please direct transfer.
So at this stage, that cannot be passed.
A decree in favor of a non-party where it is not the subject matter of the suit. He is saying, pass a decree now before the suit is heard. And he has taken no steps to have his suit heard. But the suit is now pending for how many years? 26 years. He is happy. The company is in limbo. He had wanted that status quo. He has got it. Now, seeing it is taking time, instead of pressing ahead with the suit, he is saying, okay, now please transfer the 560 shares so I become majority. Now, that status quo can't be upset. That too by way of a mandatory injunction at the interlocutory stage. Lord, your lordship knows not the law starting from 1956 Calcutta, followed in blood 1985 Calcutta non-known pictures and blood. But the law is that the court will rarely pass a mandatory injunction at the interlocutory stage, and that too only to preserve the status quo. It cannot be to not change the status quo. So what he's asking for is changing of the status quo.
All right.
Now, in addition, just 2 points, before I wind up, 2 points. Now, my lord, your lordship will see over here, the applicant is a relative of the plaintiff. Complete suppression in the application that he is a relative and this will upset the status quo in the company. So, my lord, on the ground of suppression also, it should go on that point alone. My lord, your lordship is aware of the judgments. I don't think we need to burden your lordship with judgments on suppression. These are too well-known, my lord, the principles. But, my lord, very clearly, suppression. Now, in my opposition, I disclose this fact, that he is a close relative. He has filed a reply. There is no denial of that fact. So, the fact of suppression, my lord, stands admitted. But lastly, 2 points over here, not connected to each other. Principle of not either limitation or delay acquiescence waiver. Now, fact of the matter is that not by a letter of
page 20 of your opposition.
and a letter date the
Letter of 20th or 26th of February.
Lord, 22nd of July 1997, he applied for transfer before the administrator general. 26 years have gone by. By Milord, no, Milord, that is at Milord page 20 of the affidavit in opposition filed by me. Milord, your lordship can make a note. Now, the question is not by any stretch of imagination, this would be barred by limitation 20 times over. Not the act says that if the board does not allow the transfer within a certain time, not 90 days, not it is deemed to be a rejection and you go to the CLB, not then it was the CLB, you go to the CLB and take your relief. Under the new act also, Milord, similar provision is there. So, Milord, it would be barred many times over, number one. Number two, Milord, I don't need to argue this point of limitation, Milord, that will be subject matter of proceedings before the NCLT, which is the proper body to decide whether this rectification of register or transfer should be allowed or not. But Milord, letting that aside, Milord, as far as this court is concerned, this court can't decide the question of limitation before that court. But Milord, what your lordship can certainly hold is there has been Milord, unexplained delay in approaching this court. 26 years. There should have been one line of explanation. None. None. So, Milord, even if delay can be condoned, there have to be reasons, there have to be grounds. Nothing. Nothing.
All right.
So, Milord, on these grounds, Milord, the application should be dismissed. Milord.
Who is for the other side?
My lord, I appear for the plaintiff, my lord. Kindly hears me, my lord, because it is in my suit that this application has been made. My lord, kindly takes the affidavit
Lord,
in
can I
opposition.
just show your lordship the sections once? Not the section.
Screen away.
my lord, kindly takes the affidavit in opposition which has been filed by the plaintiff in
Before
this
my
proceeding.
learned friend, my lord, one sentence, my lord, if your lordship, one sentence, my lord, I forgot to add. Like I said, the appropriate body is NCLT, not CLB then, NCLT now. And my lord, under the Companies Act, my lord, it will have exclusive jurisdiction to decide the issue. There is a ouster of jurisdiction as far as this is concerned. But that is my submission.
My lord, this is an yes, my lord. I am for the plaintiff, my lord. In my suit, this application has been filed by an intervener seeking certain orders relating to, my lord, these, my lord, minuscule number of shares. My lord, the question is whether it may sound that the plaintiff is supporting, my lord. I proceed on the premise, and lordship, for the time being, I proceed on the premise that he is a person set up by the plaintiff. Even then, the question would be, my lord, whether the intervener will be, my lord, will have to wait till such time this proceeding ends to, my lord, establish his right to his shareholding, particularly when there is no embargo as on date. Why I say this, my lord? Kindly takes the opposition, my lord, filed by the plaintiff, my lord, in GA 15. Kindly takes that opposition, my lord.
But could I have your lordship's leave, my lord? Deeply.
Yes.
My lord, may kindly come to the order at page 19, 12 September 1996. Initially,
Page?
there was an interim order. My lord, page 19, 19.
This is affidavit affirmed by?
My lord, this is an affidavit affirmed by Mr. Rajesh Kanoria. Rajesh Kanoria, my lord.
Defendant এটা দিচ্ছ কেন? Plaintiff এর affidavit দাও। Yes.
My lord, page 19, my lord, an order dated 12 September 1996. My lord, this is on the application filed by the original defendants that this order was passed. My lord, their contention originally was that the plaintiffs number 2 and 3 cease to be the directors of the plaintiff number 1. Kindly, my lord, marks the last 3 lines at page 19, the finding of the court. At page 19, until further investigation is made, it is difficult to accept the contention of the defendants 1 and 2 that plaintiffs number 2 and 3 cease to be the directors of the plaintiff number 1. Then kindly turns the page, the second paragraph. In the suit, there is at least one evidence coming from an independent authority, namely Administrator General, to the effect that it has not received any notice of any such meeting up to 31st May 96. In that view of the matter, also it does not appear to me that I should proceed to accept the story made out by the defendants 1 and 2 as regards increase of share capital and granting of authority to the board to issue allot shares of the increased portion.
What is the sum and substance of your argument?
My lord, the shares were the subject matter after, my lord, rejection, my lord, this order which I am showing, the shares were the subject matter of us, my lord, proceeding before the CLB. My lord, there also, my lord, a contention was raised that independent proceedings relating to these shares declaring that the transfer was bad, this was done by the defendants at that stage. They failed, my lord. I want to show that to your lordship. This, my lord, argument, entire argument, it was, my lord, made then also, and this was negated by the court. Kindly gives me, my lord, 2 minutes to, my lord, draw my lord's attention to 2 orders.
Be pointed, make pointed submissions.
Yes, my lord, kindly allows me to place this page 20 and then I'll straight away come to the CLB order. My lord, page 20, the last paragraph I was reading, my lord, 10 lines from the, my lord, bottom foot of that page. The defendants 1 and 2 have relied on documents said to have been filed with the Registrar of Companies West Bengal in the month of August 96 to show authenticity of the actions taken about in their application, but unfortunately for them, those documents do not show anything except a peculiar version of the signatory of that document. In that view of the matter, it appears matter requires investigation. In the meantime, manner in which defendants 1 and 2 have acted in the matter and held board meetings in violation of court's order, it is necessary on my part to give appropriate directions for the protection of the assets of the company and its employees. And it is, my lord,
this order was passed in adjudication or hearing something, a dispute pending between the plaintiff and the defendant.
Yes.
Your submission should be whether this intervener's application should be entertained during pendency of the suit without hearing or without adjudicating upon dispute between the parties. Why a third party who doesn't want to be a party at all, as Mr. Bachwa submitted, should be entertained. Be pointed
Yes.
the answer.
My lord,
Give a
kindly comes to
pointed answer
page
to this.
44. My lord, kindly comes to page 44. After this, my lord, proceeding, a CLB proceeding was, my lord, filed. A proceeding in the CLB was filed. Kindly marks who are the respondents number 6 and 7. At page 44, it is the
Yes.
Administrator General and Sunil Kumar Jalan.
Yes.
Kindly turns the page, comes to page 45. My lord, the petitioners here are the same original defendants who were, my lord, Guljari Lal Kanoria and Chandra Kumar Kanoria. They, my lord, prayed for, kindly marks prayer E at page 45. This was the prayer made to declare that the purported transfer of shares by the 6th respondent to the 7th respondent is illegal, invalid, null and void. This was the prayer made. Kindly sees the order passed by the CLB, my lord. At page, my lord, 53, kindly comes.
Page
53.
Yes.
The facts and circumstances of this case in so-and-so cited by counsel for petitioner can be distinguished from the facts of the present case, especially in the former case. High Court has held reliefs asked for in the civil suit are different from the relief sought in the company petition. In view of the foregoing, since the civil proceeding before Calcutta High Court is prior in time to the filing of the petition before us, to avoid conflict, we are inclined to stay the proceedings before the CLB till disposal of the civil suit on the file of the High Court, and accordingly proceedings in company petition are stayed. So, my lord, there is no declaration today that the transfer is bad. The transfer made by the Administrator General in favor of the applicant intervener.
Which page you are referring to?
Page 53 and 54, last paragraph I read, my lord. 53 and 54.
All right.
Then, my lord,
So
it
that
was
is,
carried
according
in
to
appeal.
you, that is undecided.
Yes. So, my lord, there is no declaration as on date that the transfer made by the Administrator General in favor of the intervener applicant regarding these shares is bad. There is no declaration to that effect. Now, there was an appeal, 10F appeal carried to the High Court. Kindly comes to the order at page 55. The relevant portion is at page 74.
Yes.
My lord, at the top, lordship kindly marks page 74. We have no manner of doubt that the proceedings before the company law board cannot proceed without deciding the merits and contentions of the issues involved in the suit pending in this court, and as such the order passed by the company law board staying its proceedings cannot be said to be of any merit. We are of the view that the decision cited by so-and-so for the appellant does not apply to the facts of the case. Kindly turns the page 75, last paragraph. In our view, there is no question of law involved which requires determination in appeal under section 10F. As such, petition stands rejected. So appeal on that ground was also rejected. Appeal preferred by the same defendants. So, my lord, the position as it stands is there is no declaration since 1996 after that transfer made in favor of the intervener that the transfer is bad. Now, in such situation, can the, my lord, intervener or should the intervener wait till, my lord, adjudication of the issues involved in the suit would be the question to be adjudicated.
All right. Reserved for order.
My lord, I
has to say
I appear, can't come forward and say, my lord, that the intervener will have a
Lord, I appear on behalf of the applicant, Lord. This is my application.
Now,
I have heard your application.
My lord, may I? My lord, Mr. Ghosh is leading me in this matter, my lord. Mr. Ghosh had placed the application, Dhruvo Ghosh, my lord. He had placed the application, my lord. My lord, there are several factual points that have been stated in the reply, my lord. There are 3 legal points, as I understand. The bar under 430
to law.
To law. There are 3 legal points that have been involved. One, the bar under section 430 of the Companies Act, that whether the civil court today can entertain this proceedings, which is in the nature of section 111 of the old act and in the nature of section 59 of the new act. Well, the second is with regards to limitation as to the deep slumber of 26 years that the applicant has now approached. Well, the third, as I understand, Mr. Bachawat's submission is with regards to the fact that after 26 years, I have been set up by the plaintiff to do what the plaintiff could not do. My lord, these are the three facts, my lord. My lord, on these points, my lord, maybe we given 15 minutes, my lord. Mr. Ghosh is addressing, my lord. That is the only reason why I ask for one accommodation today, my lord. Mr. Ghosh is not here for 15 minutes of time, any day.
Just a minute. Jishnu will come. Jishnu will take his chance now. He can't take down account of Jishnu now.
Heard in part adjourned to 11th March.
My lord, he will only restrict on the point of law. My lord,
He
point
will
of
answer
law.
the queries of the court.
Yes.
My lord,
He has not been
And what you have submitted, you will answer.
my lord, could it be on 13th of March, my lord, subject to your lord? My lord,
Any day.
11th, my lord, I am in some difficulty. That is
My
11th.
notes are ready, my lord. If your lordship wants, my lord, I can use file my notes.
Deeply obliged.
My notes are ready, my lord. If your lordship wants, I can file my notes.
That's up to you.
Very well. बोलो दाओ.
Milord, I appear for the respondent number 2, Milord.
ठीक है রেখে দাও.
May it please your lordship, Milord, I appear for the respondent number 2, Milord. I am led by Mr. Jishnu Chaudhary. On the next occasion, we shall also address your lordship on this, Milord.
If the
If
court
your
thinks
lordship,
necessary, then it will be.
yes, Milord, we
Next matter.
My lord, 13th of March, your lordship.
Yes.
Deeply obliged.
Item number 5
No,
and 8.
one thing I like to make clear. After his submission, Mr. Chaudhary will not come and say, I have to say something.
Yes.
I will just close it because
Yes.
it is pending for long.
Milord, before my learned
Come
friend
next
begins,
day,
Milord.
5 minutes time I will give.
Very well, Milord.
You
Very
make
well.
submission, then I will hear him and I will close
Very
it.
well, Milord. We shall do it in 5 minutes.
That's all.
Very well.
No further submission. It will go on.
No, Milord, we are.
The judgment, my lord, lordship gives me to distribute. That's all. In
No, I
reply-
cannot hear. I have got it late. I have to answer. That thing cannot be made.
Absolutely.
No,
He
Milord.
cites any judgments. Factually, we are finished, my lord.
If you want to cite any judgment,
No, I don't want. If he cites, my lord, gives me chance, my lord, to, my lord, distinguish.
Yes,
It shall not take more than 5 minutes, Milord. Grateful.
Item number 5 and 8.
Milord, I am
Please,
for
Chandra Ojha.
Mukesh Ojha, Milord. Defendant number 3, Milord. Transfer.
Defendant number 6.
Mukesh Ojha, the plaintiff number 3. She transfers.
Transport.
Milord, I only, Milord, my affidavit in reply is being affirmed now. My client was not well. But kindly come keep it on next week, Milord. Every day, Milord. And only one thing, Milord.
last chance is given to file affidavit in reply, which is yet to be filed.
And Milord, one thing, I find Milord defendant number 9. He is long dead. Plaintiff probably is not
Check it, Mr. Rai.
Pramod Rai Ojha. Long dead. Not now. Inform করে দাও তোমার টাকা তুমি সব ডিপেন্ডেন্টের কাজ জানো না গ্রেটফুল মিনিট
কি বললাম
but kindly record also the defendant number 9 given to file
affidavit in reply.
Which is yet to be
The matter will appear in the list in April, 5th April.
and both the matters Milord. Both 5 and 8
5 and
8 Milord.
8 means
Milord, kindly
Yes.
also
both the matters will appear in the list on 5th April.
Milord, kindly record that defendant number 9 has long
Mr. Sen submitted that Mr. Sen appearing for
the defendant number 6
defendant number 6.
6 and
6 and Mr. Banerjee appearing for defendant number 10 submitted that defendant number 9 has long expired.
yes
Plaintiff is to take steps accordingly.
Milord, very grateful Milord.
Item number 6.
I appear for the applicant in this matter. This is the matter, my lord, where we filed an application under section 430 of the Companies Act.
Yes.
We have completed our submissions.
Which other side?
My lord, I am not aware. Mr. Abhijit Mitra was making submissions on the other day. Very good.
No, this is that argument of Mr. Banerjee that section 430 of the Companies Act has retrospectively non-suits me. I had dealt with his judgment, Lordship, since he has not argued, and it is not the case that when the suit was filed, the court had jurisdiction. I will not trouble my lord with the last judgment I gave, Asansol Electric case. I will come straight away to whether this section 430 retrospectively ousts the court's jurisdiction to entertain the suit. For this, Lordship, I am relying upon and that and the main thrust of Mr. Banerjee's argument, Lordship may recall, is the language of 430 which uses the word entertain. So he says entertain means entertain even today. You cannot enter, a lordship can entertain any state. I firstly give me 18 Calcutta. Sanjeev Banerjee. In that context, I'll cite one judgment because section 34 of the Sarfazi Act also has the word entertain used. So, give a copy. Give a copy. Give them also a copy of it. You kindly takes a look at AIR 2018 Calcutta, page 8.
Yes.
Lordship kindly takes a look at paragraph 14, where section 34 is quoted. Civil court not to have jurisdiction. No civil court shall have jurisdiction to entertain any suit in respect of any matter.
You are referring to?
Paragraph 14, where the section 34 of the Recovery Act, I think, Recovery of Debts Act, has been set out, not Sarfazi Recovery of Debts. No civil court shall have jurisdiction to entertain any suit.
Yeah.
So that's similar provision. But there's no provision for transfer of suits. Now, in that context, Lordship kindly comes to paragraph 20. The statutory prohibition contained in section 34 of the Act is not unique. There are several contemporary statutes, particularly in the modern trend of emasculating the judiciary and increasing the parking of matters with tribunals under executive control, which contain similar provisions. Section 15I of the SEBI Act, 23 of Depositories, 140 of Electricity, and 430 of Companies Act, to name a few. Now, this is now kindly come to paragraph 33. 33. As comprehensive as the bar is under the first limb of section 34 of the Act, the only construction thereof is that the word is in the expression is empowered by or under this Act to determine operates only in present time. A DRT or DRAT has to have authority to determine the entire subject matter of a suit at the time of its institution. For the bar under the first limb of such provision to be attracted, if the authority to determine the subject matter of the suit vests in DRT or DRT after the institution of the suit cannot be regarded as valid. It is here that the second limb of the suit cannot be, it is here that the second limb of the provision takes over, as it prohibits the interdiction of any action taken or to be taken in pursuance of any power conferred by you under the Act or under the Act of 1993. Thus, a plaint cannot be rejected and simply refused to be received if no DRT or DRAT is empowered to determine the subject matter thereof at the time of institution. And that is not to say, however, that even if the bar operates and the suit is accidentally received, the plaint which can be rejected later. It must only emphasize that the bar operates at threshold, and not if a DRT or DRAT becomes vested with authority to determine the subject matter of the suit at any time after the institution of the suit. So, in the context of the word entertain. Now, Lordship, entertain context, I'll cite one English judgment because beautifully put in this, and then I'll just show a full bench Supreme Court where this English judgment has been followed. Give me that English judgment which I gave, but Lord Buckley, Smithy's case. Yeah. Give them a copy. Give them. I'll just give you. Yeah. History. Oh, I'll give. Fine. This is a Court of Appeal judgment in Smithies versus National Association of Operative Plasterers. There are judgments in two parts. One is on the jurisdiction, then on the merits. Lordship, kindly come to 319. 319 of this King's Bench judgment. I should kindly come to Lord Justice Buckley's judgment at 319 bottom. I mean, Justice Vaughan William has said that the same thing, but Buckley's language is very apt and has been quoted several times by the Supreme Court. Lord Justice Buckley's, I am of the same opinion. Before the passing of the Trade Disputes Act of 1906, the plaintiff brought an action which he was entitled to bring. The court was entitled and indeed bound to hear it, for that is the purpose for which the court sit. The action went on a preliminary question to the House of Lords. Then this Act of Parliament, when
this should be possibly when?
Should be when later. It contains the words, "An action against a trade union shall not be entertained." An action against a trade union shall not be entertained. The respondents say that these words are equivalent for the purpose of this case to "shall cease to be entertained." This is the sum and substance of Mr. Banerjee's submission. I do not agree with that contention. It involves that an action is to be treated as though there was no action at all, although costs had already been incurred before the act has been passed. The section cannot probably bear such a construction. This has been followed variously in Supreme Court by the Supreme Court, that entertained cannot be taken to such an illogical conclusion as to affect a pending suit and leave the person remediless. It's one thing if the suit is transferred, like the judgment which Mr. Banerjee had cited. If there was provision for transfer under Order 7, Rule 10 for transfer, then it can be transferred. That I showed there is
return of plaint. Order 7, Rule 10, return of plaint.
Is return of plaint for presentation before another court. So if there's the equivalent provision, that may have applied, because that act could have been brought in and said that pending proceedings, pending suits, which are now covered by Section 430, will be transferred to the National Company Law Tribunal. In fact, there is a similar provision in Section 434, which covers a class of cases, like winding up schemes, to be transferred to the National Company. But for suits, there is no such equivalent provision for transfer. So that's why I can't be simply non-suited and dismissed and say you file a fresh suit, I'll give you a Section 14 protection and you go. That is not the law, Mother. Well, this passage has been followed by the Supreme Court in, give me that Supreme Court, 77-1 SCC, 77-1 SCC, 3-judge bench, 77-1 SCC or 77. I think so. I sent him the thing. No, they haven't taken an SCC also. Doesn't. Yeah. Yes. So it. 1977 1 SCC 593. The second last page, paragraph 40. On retrospective application.
Against Smithies.
Yes. Again in Smithies versus National Union of the so-and-so, Section 4 of the Trade Disputes Act, which enacted that an action for tort against a trade union shall not be entertained by any court, was held not to prevent the courts from hearing and giving judgment in actions of that kind begun before the passing of the Act. It is a general rule that the legislature alters the rights of parties by taking away or conferring any right of action. Its enactments, unless in express terms they apply to pending actions, do not affect them. But there is an exception to this rule, namely where enactments merely affect procedure and do not extend to rights of section. See Joseph Sucha. If the legislature forms a new procedure alteration in the form of procedure, the retrospective, like if a new form is required to be filed, a reaffirming has to be done, then that will be procedure. In other words, if a statute deals merely with the procedure of an action and does not affect the rights of the parties, it will be held to apply prima facie to all actions pending as in future. Now I will show a Bombay High Court judgment where section 430 was held to be not procedural, but a substantive law. In the context of a civil suit that was pending, which, as in this case, it was argued by the other side that this is covered by section 241. So section 430 will retrospectively house Kathawala's judgment. Kathawala's judgment, give me. House the civil court jurisdiction and the suit should be dismissed. In that context, the Bombay High Court held that section 430 is not a procedural provision. It takes away the jurisdiction of the court. So this cannot be retrospective.
All right.
Good. Ashok kindly comes to paragraph 4 of this judgment. Although the application accepts and admits that the company petition having been filed and allowed much prior to June 1, 2016, is a saved petition and continues to remain with the jurisdiction of this court. The learned advocate for the appellant submitted that by the coming into force of section 430 of the Act of 13 Act on June 1, 16, this court has lost all its jurisdiction over the winding up proceedings. That the order granting leave under 446 ceased to be alive. It was also submitted that section 430 of the 2013 Act is a procedural provision that otherwise operates retrospectively. It is further submitted that all orders passed in the suit also are a nullity as a result of the aforesaid submission. Now, Lordship kindly comes to paragraph 13, where paragraph 11 onwards. Section 430 of the 13 Act ousts the jurisdiction of a civil court to entertain a suit or proceeding which the tribunal is empowered to determine under the 13 Act. 430 is quoted thereafter. Paragraph 12. It is expressly clear that section 430 of the 13 Act, which was not even a statutory provision in force at the relevant time of orders in the present company petition, can have no bearing on the authority or jurisdiction of this court to grant leave under section 446 of the 1956 Act in a petition that was and continues to remain within the jurisdiction of this court. At the relevant time, this court undoubtedly had jurisdiction to consider the application for leave under 446. Moreover, this court has accordingly continued, and it is also clear that the suit being for recovery of money is not in respect of a matter that even after coming into force of the 13 Act is within the jurisdiction of the tribunal or appellate tribunal. Further, I also find no merit in the submission that section 430 applies retrospectively because it is a procedural provision. It is clearly not a procedural provision, but a substantive provision on the ouster of jurisdiction of a civil court. And in any event, apart from the issue of retrospective operation, I find there is no merit in the submission relying on Section 4.
All right, next.
This really should more or less enough, but then Lordship acted now 91 supplementary 2, one last judgment, Lordship. I will not trouble my lord with any more because the law is very clear. Very clear in your favor. Happy? Now, 91 supplementary to SCC.
What's the 91?
Supplementary to SCC 649.
Page?
649, 91 supplementary to SCC for 649.
You're referring to paragraph
4. Of course, the word entertain is not there, but all the other judgments had the word entertain. But the general proposition, Section 4, in the context of Industrial Disputes Act. The main challenge to the civil court jurisdiction is by placing reliance on Section 2A of the Industrial Disputes Act. On a reference to that provision, we find that on the happening of certain eventualities, the reliefs available under that provision can be asked for. On June 7, 1988, none of the situations contemplated under Section 2A had happened, so as to give the appellant a cause of action to approach the industrial court. It cannot be doubted that the maintainability of the suit has to be decided with reference to the date of institution of the proceeding. And since on January 7, 1988, when the civil suit was filed, none of the eventualities covered by 2A had happened, appellant could not have approached the forum in the 47th Act. So, suit has to be tested on the maintainability of a suit has to be tested with reference to the date of institution. And then paragraph 5 elaborates that further.
Yes.
Well, this is all. Some more of his cases were to be distinguished, but I don't see any of my juniors. If Lordship wants, in my short note, I can distinguish.
Come with the short note. Both of you. You have filed your notes?
My lord, we are ready, my lord. I need to distinguish, my lord, my learned friend's judgment. Can you, my lord, give me, my lord, any...
You file it today?
No, we shall also come the next day with the notes.
I think my learned friend has finished his submission. So, my lord,
Yes, I will only distinguish them, but then my judgments I have no more to cite.
Or in part adjourned to 8th April.
Grateful to her.
8th April.
I have other matters also.
My lord.
Today we are running on 7th.
7th, my lord.
We'll get only 2 weeks this month.
Yes, my lord.
Last week is almost, nothing will happen.
Last week is not there. This last week is a holiday month.
Last week is holiday.
It's a holiday week.
Week-long holiday.
Very well, Mal.
In fact, none will be there in the mood to work.
No other will be there.
My lord, first week of April, my lord, is it possible? I don't know, my lord, 2nd, 3rd or...
4th April?
Very, as your lordship.
4th, 5th?
4th.
4th April.
Grateful.
Yes, grateful.
Very interesting points of law involved in this
Yes,
case.
my lord, it is. My lord, I'll try and, my lord, assist my lord, to the...
Item number 7.
Grateful.
Contrary to Lordship's last order, my lord, I am filing a supplementary affidavit by annexing the original death certificate, admittedly which was not filed.
Is it part heard?
Yes, sir. We had this matter on many occasions. But the brief, my lord, the fact of the case is that the petitioner filed an application for grant of probate of the last will of the deceased.
এটা কোনটা বলছো?
Ashim Kumar Singh. But this is the original death certificate as per the Lordship's last order, my lord, I am filing.
No, I didn't get any copy of this supplementary affidavit.
Because I forwarded it to you. Just death certificate, nothing else.
তো ডিল তো আর কিছু নেই ওখানে
No, nothing.
No, I will not hear it. It is not part-heard matter.
It is a part of matter.
No. Change of affidavit was ordered.
On 31st January, it is opening paragraph of the order, it is written as a part of.
The suit is not part-heard, in fact. This application was only part-heard.
Yes,
For application for grant of probate.
GA6 was part-heard, that was disposed of.
Yes, that was it.
GA6 was disposed of, that was part-heard. Now nothing is part-heard.
And this is under Rule 30. Naturally, it is part
No, no, this cannot be under part-heard. Go to the proper court. I have no testamentary jurisdiction right now.
Logically record this, but the filing today, the supplementary affidavit.
Supplementary affidavit is filed today by the petitioner.
But I have not been served with a copy.
Just now I will.
Serve copy.
Yes.
The matter is released from this court to place before court of competent jurisdiction, to before appropriate bench.
Item number 9.
আমি কোথায় বলছি সেখানে জানবে আপনার কাছে কপি নেই
I appear for the, as one of the receiver, my lord. My lordship had directed us to make publication, my lord, subject to the approval of the learned registrar. My lord, we have written to the registrar along with the.
It is yet to be published.
My lord, registrar has not granted us the. Subject to approval of the draft notice. My lord, the draft notice is also there, my lord, which we have forwarded.
Why it was not done?
My lord, we have written to the registrar on 13th of February. Lordship, kindly see my. They have received the office of the registrar has received on 13th of February. My lord, we have not got this approval yet.
The learned receivers take it back. When this order was passed, publication.
My lord, Lordship, 30th of January. My lord, this is the order.
এটা অন্য ম্যাটারে দিয়েছো। Draft notice was submitted to the learned registrar original site by the learned receivers, comma, as submitted, but the same is waiting for approval. Full stop. The learned registrar original site shall expedite approval of the draft notice for publication. Let the matter appear in the list on 17th April.
Item number 10.
I am appearing on behalf of the plaintiff petitioner, Your Lordship. Your Lordship will remember this is that application made by the plaintiff for appointment of a commissioner because there was a discrepancy in the space occupied by the defendant numbers 1 and 2. Hence, we had completed our arguments. We had shown that there is a discrepancy. We had prepared the schedule in the plaint on the basis of the RTI replies we got from KMC with regard to the certificate of
Yes,
enlistment.
there's a discrepancy. Yes.
Yes, your lordship.
My lord, Mr. Dheeraj Trivedi is appearing on behalf of the defendant. He's in some personal difficulty today, my
Your
lord.
lordship,
I'm only praying for not
it's
today.
the only difficulty is this, your lordship. I won't have opposed. The suit cannot be proceeded with unless this application is
This is
disposed of.
personal appearance. Adjourn to
A short date, if your lordship
not
possible.
this month.
Huh?
9th April,
Your lordship.
comma, on prayer of the learned counsel for
Defendant.
defendant.
Your lordship, in that event,
No.
kindly keep it at least peremptory for the arguments, your
Further,
lordship.
no further time will be allowed. I will pass order. Next day I will pass order.
And
Keep it
your
in
lordship, he's appearing for defendant number 1 and 2.
Defendant number 1 and 2. Yes. Next.
Item 11. Lord, okay. Lord, I appeal for the respondent contemners.
I appeal for the applicants.
Lord, Mr. Gupta had concluded his submissions on the last occasion, my lord. I am to commence my submissions. The primary issue, my lord, is twofold. One is, my lord, the allegation as to the commission of the act of contempt. And secondly, my lord, whether, my lord, this contempt petition is maintainable in view of Section 20 of the Limitation Act. The allegation is, my lord, that the order which has been violated is an order of 23rd of February 2009. Admittedly, this order was passed, my lord, in presence of both parties. What has not been indicated to your lordship is this, by Mr. Gupta, that the order which restrained the alleged contemners from dealing with particular property, it was passed subsequent to the property having already been gifted.
Point is, yes, the deed was executed prior to the passing of the order.
Yes.
But it was
Registration and stamp is subsequent.
That means giving effect after passing of
Yes.
the order.
So the perfect, it would be my endeavor.
It is not effective unless it is registered.
No, my lord. Only one thing. Because it's a deed of gift, the distinction between registration of a conveyance and a gift has to be drawn.
Did you ask for any permission from the court that we have stated this, we have made execution of a deed of gift, we need to register?
No, man. That was not done. That was a completely incorrect stand taken. It should have been done.
That shows absence of your bona fide.
That, my lord, it can also show the other part of it is this. Perhaps, my lord, the alleged contemners were not adequately advised. Contempt has to be willful and deliberate. Contempt cannot be if I have no intention to lower the dignity or the majesty of the court. That will not tantamount to contempt.
Why did you go for registration then, knowing this fully this order was passed?
That is what I'm saying. That is where, my lord, if a particular person has been ill advised, I will come and address to your lordship to that. If the intention is not willful or deliberate, and it is based.
So your point is two. One is there is no willful violation of the order of the court.
First is limitation.
Yes. Second is limitation.
No, because limitation will precede everything else, my lord.
What is your judgments in favor of limitation?
I'll show it from their own pleadings and their own documents that they had knowledge way before they filed this contempt petition. Contempt petition is of 2023. After the passing of the order in 2009, my lord, the receiver was appointed. Receiver goes, visits the premises in 2009. Lordship, kindly see what is recorded in the receiver's report.
What is that?
It is annexed. I'll just give your lordship the page
Annexed to
number.
what?
To the contempt petition.
Page?
I'll give your lordship the page number. My lord, it's at page 67.
Yes.
Lordship has that report of the special officer.
Hmm.
Now, my lord, paragraph 1, pursuant to the order dated 25th September 2025, passed by such and such. Now, if your lordship sees, this report 10th November 2014 at page 69. Paragraph 7 and 8. Paragraph 7. In the above facts and circumstances, the special officer takes symbolic possession, takes inventory of the assets in question in the aforesaid manner in pursuant to the order dated such and such, passed by the Honorable Justice Shomensh in presence of all the persons present at that time. Immediately thereafter, all of a sudden, one Ratanlal Joshi, advocate, address is mention of the address, appeared at the end of the minutes, appeared for the judgment debtors numbers 2, 3, and 4 before the special officer and submits that the judgment debtors are not the owners of any part of the building, but they are all residing and or occupying the part of the building as bona fide tenants.
Judgment debtor number 2, 3, and 4 are here contemners.
Are the alleged contemners.
Part of the building has bona fide tenants since 2006.
Yes, my lord.
Where is the mention of the deed of gift?
They have been, it has been indicated that they are not the owners. The order, Lord, if your lordship is pleased to take the order, which is at page 39, deed of gift in fact is mentioned, my lord. I'll also show that. Tenant receipts are there. Order is at page 30. If I may please the same, my lord. Counsel for the respondents submits that since 2006, the respondents have discontinued their business at Kamak Street. All correspondence have been addressed at Alipur Park Place and received thereat as no part of the cause of action is written in the jurisdiction. Having considered the submissions of the parties and as no application has been filed for rejection of the plea and from the facts pleaded, it appears that sums were lent
Which
in
you are referring
advance.
to page?
Page 39, my lord. This is the order. 23rd February 2009.
Yes.
They shall be entitled to an interim relief. Accordingly, there will be an order in terms of prayer E of the notice of motion for 8 weeks. I take it, my lord, notice of motion injunction restraining me from dealing with the property. The reliefs are at page 52.
You show me where this is mentioned. How can you say that you have the knowledge?
The
petitioner had knowledge. You said the petitioner had knowledge,
Yes,
and there are ample evidence to,
yes, my
to
lord.
this to show this.
Page 67 is the minutes, my lord. They present the minutes
Very
are
good.
preceded.
Where
Page
is this?
67.
Page
I'll
67
show
is
the
it?
minutes of the receivers where, my lord, they're represented. Handwritten minutes are there. Their receiver had visited. The handwritten minutes are at page 75. Lordship will kindly note, special officer's name is there. Mr. Shurajit Biswas, who is the advocate and record for the petitioners were present. And, my lord, the petitioner himself was also perhaps present. Which is the inventory.
Next day, you come with. I think you have not gone through the application.
Absolutely, I've gone through, my lord.
Then
Their
why
entire
are you taking
plea.
so many time?
It is their entire plea is.
You show me how you can say and any document in support of a plea that it was their knowledge, it is your knowledge or their knowledge that the gift was made, gift was executed.
My lord, if I say I'm not the owner, That is sufficient.
That is implied.
If ownership is disputed, if I'm saying I'm not the owner of a
One thing.
premises,
That is
that
one
would
thing.
mean that they had knowledge that
Anything
I'm not
else?
the owner.
Anything else?
I'll show, my lord. I'll establish from their own
What is that?
documents.
Mention the paragraph, pages.
Yes, my lord. Page 82 is the type copy of these minutes. In law, my lord, knowledge need not be that gift has been made. If a statement is made that these persons are not owners, they're aware that I'm not the owner. So as a result, the injunction does not operate on me. At page 84. This is the same thing as recorded in the judgment. Debtors are not owners of any part of the building and are residing in premises as tenants. When the special officer wants to see tenant receipts, they produced one current and old tenant receipts. Thereafter, Mr. Joshi introduced me with other occupiers of the building, visited the rooms of the said occupiers in basements, first floor, second floor, third floor, except fourth floor. But the occupiers of the fourth floor.
Notes of argument.
Lordship.
Short notes of argument.
I will provide that. I'll also rely upon judgments to establish, my lord, two facts. Firstly, my lord, the process of registration and stamping, that is perfecting of title, even in case of a conveyance. Stamp and registration does not disentitle me to ownership. It only disentitles me to enforce that document.
Come with the notes of argument, be precise. Heard in part. Adjourn to 2nd April.
My lord, the interim order.
Interim order will continue.
Interim order be extended till date.
My lord is opined that a short notes of argument is to be brought on.
Both of you.
Item number 12. Audita Sarogi.
I am for 10 to 12 defendant, my lord.
I am for the 8 and 9.
Who is for the plaintiff?
Well, just coming, my lord. So, short. That's all.
The victim appear for the plaintiff.
Who filed this application?
Yes. The application is filed, my lord.
Passing preliminary decree.
Yes. For passing a preliminary decree. Now, my lord, in the previous application, GA number 16 is before your lordship today. My lord, the compromise settlement, which was entered in GA number 16, was filed. There were some typographical errors,
yes,
which, my lord, required filing of another application under GA 17, which was, my lord, later withdrawn.
Corrections were made?
Corrections are made. Now, in GA 18, the corrections are there. If your lordship now kindly takes up, on the last occasion, your lordship was, my lord, your lordship, it has fallen from your lordship that the signature of all the parties are not present in every page. So your lordship's pleasure was that the advocates might put their signature in all the pages because all the parties are residing in different places all around the world.
Let me have it.
Yes. This is the original? No, the original is filed, right? Where is the original? Where is the original of the terms of settlement? Kindly give me 1 minute. No, where is the original terms of settlement? In 18, the corrected one. Now, if your lordship kindly takes up GA 18, where the copy is there.
Copy is there, but you are asked to sign all the pages.
Yes.
I want to see that one.
But the signature of the advocates has not yet been put in all the pages.
Then come on the next day.
But if your lordship kindly directs me, kindly pass the direction, I can put the signature and place it before your lordship.
So this court will have to pass direction. How will you execute a settlement date?
No, I'm not saying that. I'm not saying
I'll simply throw it away if it is not properly executed. It's up to you to execute a document.
So on the next occasion, my lord, I put the signature of all the advocates on all the pages and place it before your lordship.
Adjourn to 3rd April.
3rd April.
The court shall advise you to put signature,
No.
to put full stop, to put comma.
That is a mistake which has occurred.
The court will simply throw it away.
Where is the original? Deeply obliged.
That I'm for the plaintiff, Milord. But it's a partition suit where Milord, partition commissioner was appointed. And Milord, all the properties that were left in the family Milord branch have been sold out by orders of this court through public auction. And Milord, now Milord, there is no property left, and the fund that came from that sale had also been Milord, distributed amongst the parties by orders of court. Now, Milord, the learned partition commissioner, who is present, Milord, has also filed a report to that effect. And from the report, Lordship would find that right now only 199 rupees is left in the accounts of the learned partition commissioner. So, Milord, our prayer was on the last occasion that the suit may be decreed because nothing is left and it can be disposed of.
What decree will be passed? It should be disposed of simply.
Disposed of. In terms of the final report of the partition commissioner.
Suit has become now
Yes,
infructuous.
infructuous. All properties sold out and all money paid to all
What is the
shareholders.
report of the partition commissioner?
But on the last occasion, the report was filed.
GA 12 is for
Well, that was the application, Milord.
application for be disposed of.
That GF12 has been disposed of. Except that the order for disposal, that only what prayer was left out. Lordship said, I'll consider it after compliance of all other prayers. All other prayers, that was the application filed for auction, permission to auction, permission to sale. Those prayers are there. Lordship had allowed all those prayers one by after, and now the last prayer remained, which is the disposal of the suit.
Report of the learned commissioner of partition and receiver is filed, dated 26 February 2024. Report dated 26 February 2024 is filed by the commissioner of partition and receiver. Have you got copies?
Yes.
Parties have got copies and checked and verified the contents. The learned receiver and commissioner of partition was paid in full. Where have you stated sales proceeds are distributed? All sales proceeds are distributed.
Yes, Milord. All of them. Milord, at Lordship would also find it, Milord, at paragraph number, page, accounts is at page 18 and 19.
No statement in that all things are distributed.
Page 23 is the entire accounts.
Nothing is left. No property is left.
No property is left.
You come with a short note that no property is left and all money is distributed. Where have you mentioned this?
In the application J number 12, Lordship would find that properties are mentioned, and from the report, Lordship would find that all three properties have been sold thereafter. Application paragraph 27, page 14. These three were the properties that were left out. Auctions were held, and these three persons became the successful bidders. And then Lordship, if you read this with the report, Lordship would find that Lord, these properties have been thereafter sold and monies have been paid.
Come with a specific statement. Nothing is left. A supplementary report.
Well, paragraph number 3, Lordship would certainly consider once. Paragraph number 3. If that is sufficient, otherwise I'll come up with a note.
You said 199, it shows a lot of money. You said rupees 199 is kept. It shows rupees 1 crore 15 lakhs
Yes,
something.
thereafter the accounts, my lord, where, my lord, monies have been distributed to the other, all the legal heirs and
So
family.
come with that supplementary report.
Gotcha.
Because if I have to dispose of the suit, I have to observe that nothing is left, all monies are paid. Be very specific in your government. A supplementary report is to be filed by the learned receiver cum partition commissioner. How many days will you take?
Anytime next week, my lord.
Let the suit appear in the list on 14th March. আরে ঘুরিয়ে দাও তো। 14th March.
Grateful.
Item 15 to 17.
My lord, there,
Yes.
my lord. Mr. K was appearing, lordship may recall.
Which application I was hearing?
Actually, my lord,
23, I believe.
there are 3 suits. There was a foreign national, Mrs. Helen
can
Wilson.
remember.
She executed a will and she entered into an agreement for sale with Mr. Ghosh's client. So they have filed a suit for specific performance. Now, Mrs. Wilson's will has been probated in favor of my client.
Not probated.
So the probate is pending, and they have filed the specific performance agreement holder has filed a suit for cancellation of the will. There are 3 basic suits. My learned junior had argued that this specific performance matter, we filed a order 7 rule 11 that went up to division bench. Division bench said that this is not a matter for order 7 rule 11, but this is a very important matter, that whether a foreign national can enter into an agreement for sale, whether it's barred under the Foreign Exchange Regulation Act. So I'm fixing that, I'm directing that to be fixed as a preliminary issue, and that is to be heard first. Now, in that preliminary issue matter, already 2 days deposition has been given by my client. Now, my junior was arguing that this should be heard first. I think it should be heard one after the another.
Mr. Ghosh, have you prepared a short notes? I told you 3 case suits are there.
Supplementary affidavit, your lordship.
Not the supplement, it's the informal notes.
That I will, but your lordship remembers my argument. My argument was very simple. My lord, we are currently, my lord, subject to correction from my learned senior friend, we are hearing GA number 23 of 2024. That is taken out by my clients. What do I pray in GA number 23? I pray for modification of your lordship's order of, my lord, 15th of December 2023. Now, in that order, what has your lordship decided? Kindly, my lord, if your lordship takes your lordship GA number 23 and the order, it's a very, very short compass right now, my lord. The suits, yes, I agree, those suits are there, but currently the compass is very short. My lord, page, my lord, 9. GA number 23. GA number 23, page 9. If in fact your lordship sees the prayer at page 6, I have asked for an order of recalling and or modifying the order dated 15 December 2023.
What is your prayer?
Well, that is my prayer. Page 6. Prayer A, an order recalling and or modifying the order dated 15 December 2023, passed in CS number 57.
Which part you want to modify?
Yes. Now, kindly come to page 9. That is the order, 15 December 2023.
Come to page 10.
Yes, come to my lordship's memory, my lord. Page 10. In terms of the order dated 4th January 2023, a coordinate bench framed additional issues, one of which was whether the suit was filed under Section 31 of the Foreign Exchange Regulation Act 1973 in CS number such and such. This order was upheld by the division which with some modification in APOT number such and such in terms of the judgment dated 28th April 2023. Order 18 Rule 1 gives right to the defendant to begin in certain contingency as stated thereunder, and Rule 2 entitles the defendant to adduce evidence. The different number 3 raised the plea that the plaintiff is not entitled to be part of the relief in his written statement of which additional issues were framed. Therefore, the different number 3 has a right to begin. None appears for the plaintiff. Different number 3 is present and examined himself in part in chief. Further examination in chief of the different number 3 as DW1 is deferred to 3rd January 2024. Now, to this I say, first of all, my learned junior was there, but probably he should have assisted your lordship more. But that's that aside. My lord, your lordship has recorded in this order that as if the defendant number 3 is to begin the evidence, has a right to begin and begin.
But actually, it was not so.
Not so. The plaintiff's evidence, Mr. Over, and by way of a specific
In
order.
natural course, in course of time, or in course of proceeding, different number 3 adduced evidence.
No, not only that, my lord. That absolutely right, lordship. But even on top of that, there is a specific order passed by Justice Shamanto, Honorable Justice Shamanto, where Justice Shamanto has held that the evidence in the other suit will be treated as evidence in this suit also. And my lord, thereafter, my lord, we can proceed. So, my lord, plaintiff's evidence already is there. So it is not that the different number 3 is starting from the beginning, is the first person who is going in the box. That's number 1. Number 2, Mr. Dev's client is already in the box. I said that if it
different number 3 is your client.
Yes. So I said if it's possible, my
Also
lord,
give it 10 minutes, we'll conclude today.
yes, that if he concludes today, chief.
So it is, I understand. It is a case that he is being examined not in the priority basis as a first evidence of defendant.
That too. And my lord, kindly, the other point that I wanted to address your lordship is this. My lord, an additional issue has been framed. After the plaintiff's first witness, that is the father of the present plaintiffs, was, my lord, discharged. In fact, my lord, he died, and that is why his evidence could not be completed. So only to the extent he has deposed, that is to be, my lord, taken here.
To file application, I will pass order. But before that, let these things be, this order be modified.
Yes, this order be modified, and second, my lord,
Order doesn't require any
my lord,
modification, madam.
second, my lord, your lordship, my lord, kindly, my lord, bears with me when I say, my lord, that since that additional issue has been framed, so before his evidence could have started, I should have been given, as a plaintiff, I should have been given a right, my lord, to adduce further evidence.
But part evidence cannot be intervened with.
That is why I said, if your lordship kindly modifies this order, first to the extent clarifying that no, this is not that different number 3 is going for the first time, plaintiff's witness is already there. Second, my lord, in view of the additional issue being framed after the plaintiff's witness was discharged or he succumbed to death, my lord, the plaintiff will have a right to adduce a further evidence.
Issues can be framed at any time.
It has been framed after my, kindly appreciate one thing, a issue has been framed after my witness has come down from the box.
Even
So,
it
but I
can
should be
issue
allowed.
can be passed at the time of writing the judgment.
My lord, but I have, as a plaintiff, my right to adduce additional evidence cannot be shut out.
You file an application for
That is the application. Kindly see the application, the other prayers, my lord. If your lordship kindly
Order of
defaults that
recalling.
order and modifies it and includes this provision that this will not.
No, your prayer is order recalling, modifying.
So
all that.
if
That
your
I
lordship,
understand.
Stay of the suit.
If your lordship,
Then that is the
if
main
your
intent.
lordship, my lord, modifies it to the extent that yes, this witness has started. Your lordship was not told that the
You say
plaintiff has
if
adduced evidence.
This witness has started, this examination has started, let it be finished.
Complete. But then I should have a right also to adduce evidence, because
of course,
then otherwise, my lord, I do not have any right.
Why stay?
No, stay, forget it. Because till that time this is decided, your lordship should not. That's why I am not pressed it. Your lordship is hearing the matter. Only if your lordship clarifies that after this evidence is over, that is the examination and cross-examination is over, the plaintiff should also have a right to adduce evidence.
That is one thing.
On the additional issue, my lord.
Yes, but second thing is that probate application is here.
Yes, EOPLA. That is the other issue that your lordship wanted to decide whether,
My lord,
because of
this
the
will be
order,
over another 2 days.
because that,
thereafter, lordship takes up.
Second thing is that in probate proceeding, you are
My
giving certain kinds of evidence.
My lord.
And you cannot go into certain other kinds of
My
evidence.
lord, absolutely. I bow down.
So civil cases evidence
will be different. So I will have to have
an
an
issue. Say when we are going for a cancellation or specific performance, definitely you will not you adduce evidence to say whether the will was properly executed or not.
I will go a step further whether this agreement was executed, not
For
executed.
this additional issue,
And even title will be
he has
considered.
to prove that his that the executant was not a foreign national, foreign exchange
Exactly. So
regulation will not
kindly,
apply.
kindly
So totally
preserve.
different type of
So
evidence.
kindly
So let my
preserve my
evidence be
right.
over. After
I
that,
am not standing in the way of his evidence. I do not know why
23 of
Mr.
24 is filed.
All I'm saying is,
For
my
recalling,
right to adduce evidence should not be stopped and it should be preserved.
all right, please. For recalling the order dated 15 December 2023, passed in respect of CS 576 of 1990. Is it so?
576 of 1990, my lord.
while my client is here, if his evidence can be concluded,
Let
10
me
minutes,
pass the order.
Lordship.
Oh, yes.
Lordship.
Pass the order in the GA.
You will know? It is submitted that defendant number 3, it is submitted and it is apparent from the record that plaintiff's witnesses were examined earlier. After completion of plaintiff's witnesses,
Witness, my lord, only one.
witness, defendants adduced evidences in the form of oral testimony of the witnesses.
Well, additional issue was raised there.
Please. Defendant number DW1 is in the process of examination in continuation of process of witness action after plaintiff's adduced evidence and plaintiff's witness were examined. Let defendant number 3 be further examined in continuation of earlier examination,
But already treated as a part.
cross-examined and discharged. First up, Mr. Ghosh, the learned counsel appearing for the plaintiff, submitted that in view of additional issue framed after examination of plaintiff's witness PW1, in view of the fact that additional issue was framed after examination of PW1, an opportunity may be given to recall PW1.
PW1 is already, my lord, deceased, my father. My lord, any other further witnesses to be examined?
Given opportunity to adduce evidence since PW1 had expired earlier.
Well.
Leave is granted. The order dated 15 December 2023 stands modified to the extent that defendant's evidence is not in the first adduced in the first instance in terms of order 18 rule 1, but rather the defendant's witness is being examined after examination of plaintiff's witness. Full stop. Bakita examination hoya.
So what would have been better that my other witness also goes in and thereafter the defendant's witness could have gone in. That would have been better. But since this has happened, my lord, I offered that it is better that
two
his
things.
witness is
One is not additional issue. Division bench said preliminary issue. So instead of additional issue,
His
if your
submission
lordship,
is additional issue.
no,
It's an additional issue also.
the division bench said preliminary issue. There's a difference.
He had the suit on preliminary issue.
Yes.
Lordship.
Any addition in issue, whether it's
also
preliminary
there,
form,
absolutely.
is additional issue.
Lordship, one thing.
I will hear on preliminary issue.
Lordship. And secondly, since this is the issue of the defendant, number 3, he has to prove it first. That is why defendant number 3 is adducing evidence first. So order 18, strictly speaking, is not disturbed at all. Anyway,
No, this should be clarified. The defendant, it is not defendant who is adducing evidence first. That creates the confusion.
Lordship, it doesn't mean. Well, may I start with the man?
So, my lord, it is understood, my lord, that after my lord, Mr.
Witness
Sarkar's
action at this time, How can I proceed with the
Lordship,
other
10,
matters?
10 minutes. We have almost completed.
Or come at 2 p.m.?
Yes, today there's a court to rise at 2 p.m.
Because one junior member passed away along with a senior member. Two members of the bar passed.
How would you finish so many other matters?
And in that event,
Lordship,
kindly keep
few minutes, my lord, we'll conclude.
Okay.
I'm deeply obliged. If Lordship allows Mr. Dev to take over, my lord, he knows the facts better.
Senior always knows better.
My lord, only one more issue, my lord, just before Mr. Dev starts, my lord. Your lordship had also posed a query to us, my lord, in view of the order of Honorable Justice Arindam Mukherjee, whether, my lord, the EOPLA.
I will take it on the next day.
My lord, kindly, my lord, addresses that issue.
Yes.
My name is.
Everything is jumbled up. Problem is that.
That's what we said. That's what I said.
Everything is entangled.
My name is Narinder Kohli. NARINDER.
How can you hear two suits together? A testamentary and ordinary jurisdiction?
No, my lord, now, my lord, Lordship has the regular determination, my lord, till 2015. And after 2015, all has gone before Justice Rao.
No,
So
that is one thing. Second, I have no
it has also been
testamentary.
assigned to you. Assigned
It
to
is
you.
specially assigned, only because specially assigned. Otherwise, I have no testamentary jurisdiction. I have no testamentary jurisdiction.
Lordship.
That is with courtroom number 39.
Lordship.
Neither myself nor Justice Krishna Rao.
No, Lordship is absolutely correct. May I, my lord? Lord, we have got the certified copies, my lord. I am grateful to your Lordship, my lord. Witness, I am showing you a certified copy which has been obtained from the department. কি বললেন বলুন একবার না না শুরু থেকে শোন বলিনি witness I am showing you being letter dated 8th October 1993. Kindly have a look at this document and tell this honorable court what is this document about. Copy.
This letter has been written by the Reserve Bank of India to Mrs. Helen Wilson. Helen Wilson, residing at 6 Chaurangi Lane, section Calcutta 16. 16. The caption is section 31 in bracket 1 of the Foreign Exchange Regulation Act 1973. Permission to hold an immovable property situate in India.
একবার 67 টা দেখ
Please speak louder.
The letter says the property as acquired should be used solely for your family's bona fide residential purposes. Number 2, the property should not be transferred or disposed of by way of sale, lease, gift, mortgage, or otherwise in any manner without our prior permission. No new construction and or extensions, addition to the property should be made without our prior permission. The sale proceeds of the property, if sold at a later date, or any income that may acquire in investment of the sale procedure will not be allowed to repatriated outside India in any manner. Please note that the bank has not gone into the right, title, and your interest to the property in question, and the permission to hold the same is granted on the basis of information documents furnished to us.
Who had written this letter? Have you finished? Have you finished?
It has been written by Mr. R.K. Agarwal.
No. Your answer was complete to the last. Who had written this letter and to whom it was addressed to?
It was written by the Reserve Bank, represented by Mr. R.K. Agarwal, for controller, to Mrs. Helen Wilson, residing at 6 Chaurangi Lane, Calcutta 16.
How did you receive this letter?
I got this letter from Mr. Kenny Wilson, son of Mrs. Helen Wilson, who had come to India for her funeral.
But may I tender the certified copy? Last was Exhibit 3. This should be Exhibit 4, my lord.
লাস্ট কোয়েশ্চেনটা কি সার্টিফাইড কপি কিছু বলেছে? লাস্ট আনসারটা কিছু সার্টিফাইড কপি কথা কিছু বলেছে?
আমি প্রথমেই বলে দিয়েছি এটা সার্টিফাইড কপি বলে, যে এটা সার্টিফাইড কপি বলেই দেখাচ্ছি, তাই ওই জন্য জিজ্ঞেস করি। Witness,
spelling of Kenny Wilson?
K. Wilson, Mr. K. Wilson.
Witness, I am now showing you a certified copy of the document, certified copy of a document being an agreement for sale dated 2nd January 1989, which has been obtained from the department. Kindly have a look at this document and tell this honorable court in respect of which property the agreement for sale was entered into.
Mr. Ghosh, which is witness action in suit number?
My lord, this is 576 of 1990, specific performance suit.
That is item 15.
Item 15.
And this CS11?
CS11 is a suit filed by Mr. Ghosh's client for cancellation of a will.
So
and
this evidence would be taken together in both the suits.
my lord, this is relating to the additional issue, or in other way, the preliminary issue. So this evidence which I am adducing or adduced on the last 2 days relating to the additional issue is only, not beyond that, because this has to be decided at first in terms of the. Question ta pore diyeche?
Things are
It
bit
is,
complicated.
this is between
In respect of
Those things should be disposed of together.
Shaukat Ali, this is.
ওই কাগজটা কই? উল্টো কাগজ দিচ্ছে না তাহলে দেখে না ও তো উল্টো কাগজ দিয়েছে তারপর দেখ ভেরি গুড, ওটা বাদ দিয়ে দিন। Witness, I am showing you a certified copy of the last will and testament of Mrs. Helen Wilson, which has been obtained from the department. Kindly have a look at this document and tell this honorable court
Subject to correction, my
who
lord.
had executed this document.
This is in chief. He cannot ask a leading question. He has to show the document and say this is a certified copy. Do you know what this document is? The witness has to answer.
What
The
was the
witness has
question?
to answer.
What was the question?
You identify this document, what this document is.
Last will,
No, question would be you identify this document.
Kindly have a look at this document and tell this honorable court what is this
this is
document
the
about?
last will and testament of Mrs. Helen Wilson. Which has been executed by her on the 10th of September 1993 in the presence of the registrar, representatives of the registrar, and 3 other witnesses.
Whose names have been mentioned as executors under this will?
It is my name, Dr. Narinder Kohli, as the sole executor of the will.
And who are the beneficiaries according to this will?
My wife, Mrs. Rita Kohli, and myself, Dr. Narinder Kohli.
May I, my lord, tender this document? Idly can-
Myself.
Copy the copy. একবার এই পেপার বুকটা একবার দেবেন। Witness.
Things should be heard together. Why it's segmented? Suit is segmented. Preliminary.
Segment because of the order of Justice Samanto in this suit, that this issue, additional issue, whether the suit is barred or not, should be decided. That's why EOPLA can be proceeded with any day when it is convened to the court.
No, first thing is testamentary suit.
Yes,
That
first
will be
thing is
separately
that.
heard. And so far as Justice Samanta's view is concerned, that can be ignored because we are concerned with the old suit, proceeding with the old suit, and if the division bench order is there, then that's different. Otherwise, evidence will be pertinent to
Yes,
all the
absolutely.
3
Just
suits.
because of the division bench order, my lord, accepting the order of Justice Samanto, not modifying it, even except that you proved the case relating to the preliminary issue.
It can be interpreted that manner. The division bench order should
It's
not be
clear, my lord.
interpreted
That's the reason. Otherwise, I would have said you take evidence in respect of all 3 suits.
because at the time of final judgment, I may find that the suit is the preliminary point is not maintainable.
Very well.
Or I may hold that the preliminary
Yes,
point is
absolutely.
maintainable, it should be dismissed.
Yes.
If I decide that the preliminary point is in any suit is not maintainable, then we have to come back again.
But that can't be, my lord, can't be held because
So,
of
my
the
lord,
order.
subject to correction.
Whole
Subject to
log
correction.
witness action possibly is not permissible because of the orders, my lord.
Well, subject to correction, my lord, the evidence that my witness has already given, the father of the plaintiffs, that has, my lord, touched upon all issues, more or less. But, my lord, this additional issue, my lord, will also, Mr. Deb, let Mr. Deb complete. I will cross-examine, then I will adduce my
I think
evidence.
evidence should be taken in respect of the
All 3, absolutely.
all the issues.
And as far as the additional issue is concerned, it will be a little more in this particular suit.
Dragged on
No, it's not about dragging, my lord. It's about complying. May I, my lord, tell your lordship?
to division bench and clarify this.
That's
My
right.
lord, my lord.
Unless, no, they had
Kindly
gone to
grant
division
us some time, my lord. We
bench. But
shall.
they had gone to division bench. My lord, kindly, my lord, permit my.
Lordship, kindly sees.
All right, you just complete your.
Yes, complete,
yes.
my lord. My lord will observe that that portion, my lord. We will get it clarified from the division.
The very
Witness,
old suit.
just 4 or 5 questions I will conclude. Witness, I'm showing you a copy of the agreement for say. I'm showing you a copy of the document which has been produced by you, being serial number 7 of the disclosure made by the defendant number 3. Kindly have a look at this document and tell this honorable court what is this document about. ওই এটা 3টে একসাথে হয়ে গেছে তো ওই জন্য হয়ে গেছে। ওই এগ্রিমেন্ট ফর সেলটা আছে 869. What is this document about?
This is a document, a document for sale of this is an agreement document for sale of the property situated at 6 Chaurangi Lane between Mrs. Helen Wilson and Mr. Ratan Lal Marotia.
What was the consideration money mentioned in this agreement for sale?
30 lakhs.
And how much did Mr. Rathun Marotia pay to Mrs. Wilson according to this agreement?
An earnest money of rupees 1 lakh.
Marothia. Witness, I am showing you the amended plaint. Where amended plaint din? Amended plaint 576. Witness, I am showing you a copy of the amended plaint filed in CS number 576 of 1990. Kindly have a look at the reliefs claimed in this suit and tell this honorable court what are the reliefs
which
the
is
plaintiff had claimed.
What are you showing me? This
Reliefs. Read the plaint.
decree for rupees 5 lakhs.
Please read the entire relief.
A decree for specific performance of the said agreement for sale dated 2nd January 1989. B. Decree directing the defendants, servants, agents, representatives, assignees to execute and register in due form of law in favor of the substituted plaintiffs or their nominees the deed or deeds of conveyance in respect of the said premises being 6 Chaurangi Lane, Calcutta 16, in terms of the said agreement for sale dated 2nd January 89. In default, the defendants executing such deed or of conveyance, the registrar, original side of the Honorable Court, and or such person as this Honorable Court may think fit to be appointed and directed, do execute and register in due form of law such deeds of conveyance of the said premises in favor of the substituted plaintiffs or their nominees. D. Decree for rupees 5 lakhs as claimed in paragraph 17 hereof. E. In the event specific performance of the agreement dated 2nd January is not granted, decree for rupees 6 lakhs 35,000 as claimed in paragraph 18. Interim and further interest. G. Permanent injunction restraining the defendants, servants, and from transferring or encumbering or letting out the said premises, being 6 Chaurangi Lane.
Mr. Witness, or legal witness read the entire reliefs claimed in the. Mr. Witness, according to you, are the plaintiffs entitled to any of the reliefs claimed in the suit?
No, as because of the embargo by the Reserve Bank of India, Section 31 in bracket 1 of the Foreign Exchange Regulation Act 1973.
Did Mrs. Helen Wilson at any point of time prior to her death obtain any approval or permission from the Reserve Bank of India to enter into an agreement for sale with Mr. Ratan Marothia?
She did not.
Lord, I have concluded.
ওই যে অর্ডারটা বললাম তার সঙ্গে কন্টিনিউ করুন। টুডে DW1 is present. Would you cross today?
No.
Is the examination chief, is further examination in chief, which is complete.
Original channel.
When will you come?
My lord, I'll come sometime, my lord, next week. But my lord, in the meantime, your lordship had already expressed your lordship's mind regarding, my lord, these 3 suits, my lord, and the evidence.
For cross-examination of DW1.
My lord, some observation your lordship said your lordship will make in the order so that, my lord, we can get this clarified, because according to us, my lord, all the 3 suits, evidence and everything should be together.
Well,
One line
they
from
had
your lordship will
tried
help us.
earlier. I
It's not
don't
a
want
question of
to
trying.
say now.
Yeah, I will pass.
And my lord,
Well, only thing is,
as
my
per the
lordship, can I see
EOPLA,
is-
That day, next day, I will pass, consider and.
very
pass.
well. But my lord, the EOPLA, which is, my lord, which is also pending, my lord, I have mentioned already, my lord, kindly fixes a date for the EOPLA before this.
I will pass order for separate hearing.
Separate hearing only, I'm saying. Today only the
I'm
suit
not
is appeared.
passing any order today.
My lord.
Let all the 3 come together. I will pass order the next date.
My
Ajay, একটু দেখি।
And my lord,
But EOPLA has nothing to do with this.
What's the stage of EOPLA?
Well, EOPLA, my witness was there. Thereafter,
That is witness action.
witness action. My witness is over. I want to adduce another.
It is not for witness action.
Yes, and I want to. Their witness is also over in that.
No. Sorry, Rupok. It was not over. His witness was in the box. He was examined in chief fully, cross-examined by us partly, then he passed away. So it was not over.
That is witness action.
Witness action in EOPLA.
So,
EOPLA,
other witness কোথায় হলো?
So he has to start afresh.
are you sure it is specially assigned to me?
Yes, yes, yes.
But EOPLA, in EOPLA,
Is it specially assigned to me?
yes. Kindly fixes it for 1 day for witness action, my lord.
Shall be heard separately, since
My lord.
this suit is to be considered in exercise of testamentary jurisdiction, not being clubbed with the civil suits. Let EOPLA, EOPLA 2 of 2011 appear in the list on 2nd April
My lord.
for under heading witness action.
My lord.
and this matter, lordship, keeping it on.
April, my lord.
না, না, আগেরটা
The previous one will lordship fixed it on.
My client is to advanced age. There is a let the cross be over before he passes away.
না, ওটা কিন্তু April কোন করে দিবে।
He's an NRT. He'll not. He'll be with us.
18th March.
18th March.
For
And
further exam, for cross-examination.
Cross-examination.
And my lord, the EOPLA on 2nd April.
2nd
My
April.
হবে তোরটা আগে হবে।
একসঙ্গে চলবে।
Grateful.
সব থেকে বড় কথা সব।
এইটা কার কি জিনিস?
হ্যাঁ, ওই তো CSR 576 action.
Actually, my lord, with this additional issue, this specific provision suit has become scope very short.
Look, what appears to me, I'm not expressing my mind
Lordship.
or prejudging the suit.
Lordship.
If the RBI said you cannot do such and such thing, the question is whether it bars relief or bars suit.
Lordship.
And my lord, absolutely right. Only
Order 7 rule D.
one more line. My lord, whether the RBI bars the actual conveyance to be executed or the RBI that clause. No, my lord, RBI bars the enter into agreement for sale. That is the bigger point.
Those issues will be there.
Second thing, whether jurisdiction is barred or execution is barred.
Lordship.
My lord.
Because the first goes to the root of jurisdiction.
Of course.
Second goes to the root of relief only.
Lordship, absolutely right. Absolutely right.
Next.
Grateful.
Item number 18.
80.
For the petitioner, my lord. Your lordship had passed an order on the last occasion where a new special officer had been appointed for collection of the dividends. Now, my lord, there was a leave to file a supplementary affidavit. Person who has to affirm the affidavit, my lord, there is some bereavement in his family, my lord.
Mother.
So, my lord, that this kindly adjourn it. And another thing, my lord, I had suggested the name of the special officer, but my lord, he's not in a position to carry out, my lord. So my lord, we are suggesting subject.
Next I will consider.
Subject to your lordship's approval, Mr. Robindranath Boshak.
Next day. We have this time now.
But at least, but if the name can be substituted, the works can be done. My lord, this is collection of dividends. The order is on 31st of January, the order was passed.
Shoilendra Tiwari was appointed as a receiver.
Yes. So
Manage
but he is not in a position to
give me something. How can I change unilaterally? Let me know something, some paper.
Very well, your lordship will keep it as to be mentioned, then it can be done. My lord, just the substitution of the name. I will ask Mr. Tiwari to appear also.
The learned counsel, Mr. Shen, appearing for
the plaintiff petitioner.
Accommodation is allowed to file supplementary affidavit. The suit will appear in the list.
But this is an application, not the suit.
The application will appear in the list on 2nd April under heading to be mentioned.
But if it can come just for to be mentioned, my lord, for changing
That
the
day, that day.
But kindly give a shorter date, my lord.
That day.
But actually,
Now I am burdened with 2015
I understand. My lord, I understand. But this is only to be mentioned just because if the special officer takes charge.
You mention it. If it is ready, mention it. I will include.
Item 19. Well,
I appear for the defendant in this matter, my lord. Here, my lord, the reconstruction of records was going on, my lord, because the records were missing on the last.
For the defendant.
I am for the plaintiff. They are defendant applicant, my lord.
This reconstruction is yet to be done.
There is one, as per my lord's last order, the leave was granted upon to the plaintiff to file the affidavit in opposition.
No, I will not file any affidavit because it's a order 7 rule 11 demurrer application. An application is taken out only so that the suit cannot be taken up. It's a very old partition suit.
But we filed a reply.
Affidavit in opposition is to be filed. AO file.
I have not used any affidavit, my lord.
Then there is no question of filing any reply.
No, my lord.
So let
But
this
kindly fixes a date, my lord, and in the next
GS7.
week, my lord, I'm led by.
Yes, my lord.
GS7 order 7 rule 11.
In the
Yes,
nature
my
of
lord.
order.
And the other
revocation of leave under clause 12.
15 is abatement, my lord. Our abatement application.
Fix 14th March for hearing of GS7 of 2003. 2003 or?
Yes.
Yes, my lord.
2003.
And GA 15 of 2015. Two
Parties
GAs.
may exchange affidavit in the meantime if they are willing. GS7 of?
Affidavits are complete, my lord, in this.
No,
I don't intend to use an affidavit because the plaint will have to be considered only for revocation, my lord. And this is a very old suit, my lord. We have to proceed with the suit, my lord. Now, my only submission will be that, my lord, these are issues which will be decided at the time of hearing. You are saying that there is no territorial.
Come on the next date.
Yes.
14 March. Great.
Item number 20.
It is for further order.
Yes, my lord.
What
My lord
further
will
order should be
remember on
passed?
the last occasion, my lord had directed that notice be given to the developer whose agreement was cancelled, but he remains in possession of a certain amount of area, and also to two tenants, so that they can be heard. I have given notice. I believe they are here.
My lord, I'm appealing for one of the tenants over here. It is only why this notice in February 2024 that
Come here or to take microphone.
Please come this way.
My lord, it is only by this notice of 2024 that the advocate on record of the plaintiff has served upon us that we have come to know about the order of injunction. Prior to that, we were not aware of this at all. So upon instructions, I'm submitting that we will not stand in the way of the court's order right now. So we will vacate. However, my lord, for that, we need a little bit of time to look for an alternate accommodation and make necessary arrangements, my lord.
How much time?
A month's time at least, my lord.
How
is
many form
required.
of an affidavit or something like that?
My,
Appear?
if your lordship so requires, then I can, but this is my instruction, my lord.
All right.
The thing was, he was inducted in violation of an order of
All right. She is willing to hand it over.
going to step out.
Lordship.
And I believe another current standing on the same footing is Mr. Dev's client.
My lord, I am appearing for Mr. Javed Akhtar, who is a tenant in respect of a portion of the premises, my lord. My lord,
I'm giving you accommodation. I'm giving you time.
My lord.
File with an affidavit that we are ready and willing, or we will
I'm
hand
not
over.
going to. I'm not going to surrender, lordship, because I have paid substantial amount, my lord.
All right. You come with an application.
I'll come. I'll come with
Well,
them.
Substantial amount may have been paid because
I am not aware that
All right. I will
receiver has
consider those
inducted
issues.
me.
receiver has inducted him in violation of order of injunction.
All right. Let him come with an application. Because if you do not come with an application with an affidavit,
I'll come with
I
an
cannot hear you.
I'll definitely I'll come with an affidavit.
The learned counsel is appearing for the.
There's one more. I mean,
Yeah. My client also entered a joint venture agreement.
You are the promoter.
Yes, yes. That was cancelled by Justice Boshak. But in terms of that joint venture agreement, I have paid 20 lakhs of rupees, Your Lordship. I am ready. I am in possession of certain properties.
You come, all of you come with the respective affidavit. I will consider.
well, let them, my lord will not make an application. My lord will let them to state their stand on an affidavit,
Yes.
not an application.
Yes.
Let them file an application.
The learned counsel appearing for tenant and a developer.
Lordship, I'll file an application, Lordship.
Let the affidavit of
6.
service be kept on record.
Leave to file appropriate affidavit or application to make their respective submissions and prayers. Leave is granted. The same is to be filed on or before 5th April. The suit will appear.
Kindly give them a shorter time.
No,
so I
sorry.
can deal with it and come
This
back.
matter will appear in the list. I have lot of matters. I cannot give you a shorter
I'm
time.
not asking that the matter be fixed. My lord will give him a shorter time. So I
That's all on that day.
and come back on 5th.
5th April.
My lord, in that case, my lord, what will happen? If my lord give him a shorter time, I could have filed a reply.
All right. They
come
will
back on
file
5th.
their respective affidavit within 2 weeks.
2 weeks, and my lord will give me a chance to use a reply date.
Affidavit in opposition.
By affidavit reply, they are filing an affidavit. I'll file an affidavit reply. I'll file an
Affidavit, exchange of affidavits, filing of application and exchange of filing reply or affidavit in opposition shall be complete on or before the returnable date.
My lord.
Suits গুলো কি আছে?
But affidavit of service, I have served them.
Affidavit of service be kept in record. Suits. Which applications are pending?
The first 7/8 of 2015, and my lord, GA 1318 of.
You are the plaintiff. Who is the defendant?
There are a lot of different numbers. Around 70, 22.
It is in order. Let the suit appear in the list along with the pending applications. Is there any written statement? How many defendants are filed written statement? The learned registrar original side shall submit a report on date of service of summons on the defendants, comma, date of appearance, comma, if any, and date of filing written statement, if any, by the defendants. The suit will appear in the list on 8th April, along with the applications pending. You give at a catch code. Give the names of these applications within a slip, along with this.
22. Lordship, I am appearing. This is my suit. Lordship is calling 22, item number 22. Lordship, I am appearing. This is an undefended suit. This is appearing for the first time before your Lordship. There was a direction upon me on 2nd
I think
of
it should be checked. Have you checked it whether it will be commercial, go to commercial division or not?
Lordship, I'll take instructions on that. I don't think it will be a
Not
commercial.
instruction. go through the plan to understand what is the nature of dispute.
I will. It's a money decree which I am seeking of rupees
So
1
definitely
crore.
it will be commercial dispute.
I will come back with instruction, Your Lordship. Keeps it. So next week I will come back.
Not this week. Not this week.
May I have your lordship's kind leave, my lord? Lordship is aware of the fact that there's a resolution which has been passed, will not be able to be appear. The first matter, my lord, commercial, it's fixed at 2 p.m. In case, my lord, it's if it comes back the next week, my lord, I don't have any difficulty. If it comes back, my lord, tomorrow, I'll be in some personal difficulty.
Tomorrow you don't like to have it tomorrow.
If it could stand over till
week.
the next week, my lord.
দেখে নিয়ে করে দিও।
Deeply obliged.
Your Lordship, I am for the plaintiff. There was a direction to file the notes of argument. I have learned that the matter was mentioned by the defendants before the recess, Your Lordship.
Yes.
A
You will
short date may be given, Your Lordship.
Definitely next week. You will not be able to come tomorrow, but next week.
Tomorrow, Your Lordship, because Your Lordship was
You will not be able to come tomorrow. So I will not fix to
Friday,
definitely.
Your Lordship.
11th.
Sincerely obliged.
Lordship, I would like to mention GA number 6, in which there is a
Item
matter,
number?
I don't know, for the mentioning, Lordship. This item is not in the list.
Come tomorrow. This is not the time for mentioning. Date देके दिए दाओ.
24 and 25.
23 কবে ডেট হবে? 24, 25.
24 and 25.
ওই এপ্রিলে করে দাও.
26.
I'm for the plaintiff, my lord, in this.
April.
27.
সব এপ্রিলে ডেট করে দাও. Mr. Banerjee, why you are so pensive?
I was pensive because of another reason. I would be, my lord, bringing to your lordship's kind attention that in the Sally Isaac Meyer matter, your lordship had involved Kolkata Municipal Corporation with the motive that they will be repairing. They have issued a 411 notice. I'll bring those on record on 8th of March. This was not expected. I had given them notices. They had went physically to the office of the Kolkata Municipal Corporation to request them to come and take inspection and to give us prior intimation. They do not do anything. Yesterday
Then
they
I
have
have to call
come,
the engineer.
Yes, yesterday they have come and stuck Shab Bipodjonok Bari and the entire premises is under the auspice of the court. These things suddenly come. Obliged.